Good morning, everyone. Welcome. This is the time and place for the hearing examinations that have been delegated by the Board of Oil, Gas, and Mining. My name is John Baza, and I have been appointed by the board as the hearing examiner in this coming proceeding. Today is Wednesday, October 16th, 2024. This is the time and place for the hearing examiner's proceedings for docket number 2024-056, cause number 132-55, in the matter of the request for agency action of OVINTIV USA Inc. for an order pooling interests, including the compulsory pooling of the interests of certain non-consent owners, and I hope I'm getting the pronunciation right. Colorado UT 16-7 4-2-7-6-1H well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations, comprised of all of Section 6 and 7, Township 4 South, Range 2 West, USM, Duchesne County, Utah. We are holding this proceeding with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. Before we begin, I understand that there's no electronic participation by the public, but are there any members of the public or respondents in this matter that are here to comment on these proceedings?
I am.
I don't think you're here for this matter, though.
Oh.
Is that, am I correct?
Well, my mom's an heir.
But in one of the following proceedings.
I have no idea.
What's his,
My name's Meekin and my mother's name is Farnsworth.
Okay.
My grandpa's the one that initially bought in.
you want to chat with me for a minute? I'll see if
All
I
right.
can help you figure out which matter, and then
Oh, okay.
we'll butt in if it's for this matter. if
Okay,
that's all right.
yeah, thank you, Mitch.
John, if I could interject one thing. These microphones on the ceiling are very sensitive. They will pick up every conversation around the outside and put it on the official record of the meeting. So please be aware, there's no dead space in this room for the audio system. Thank you, sir.
Thank you for that. Okay, so we'll wait to hear from that party and see if they're participating in this matter. Let's take appearances of counsel for this matter.
Fred McDonald of counsel with Lear & Lear on behalf of petitioner OVINTIV USA Inc.
Gary White, Assistant Attorney General for the Division of Oil, Gas, and Mining.
Seated next to me is Carter Moore. He's an Assistant Attorney General with the AG's office, and he's advising me legally in this matter. So I have received declarations from Mr. Peter Burns and Mr. Christopher Wall in this matter. They are employees of OVINTIV. I've reviewed them before the hearing began. Does the division have any objections to these declarations or the declarants being qualified as experts in this matter?
No objection.
Okay. Assuming that we have no objections from anyone, they are recognized as experts in their particular fields of expertise for this matter. Mr. McDonald, are those witnesses available?
They are, Mr. Baza. With me today are Mr. Peter Burns, the land advisor of OVINTIV. He's waving at the camera. And Mr. Christopher Wall, who's the reservoir engineering advisor. Mr. Burns has been qualified as an expert in petroleum land management. And Mr. Wall has been recognized as an expert in petroleum engineering and for this matter. I would ask that they be sworn in at this time.
Yes. Thank you. Mr. Burns and Mr. Wall, would you be sworn in by the court reporter, please?
Can you guys see me?
Yes.
Okay, perfect. Can you please raise your right hands, both of you? Thank you. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? We'll start with Mr. Burns.
Yes, I do.
And Mr. Wall?
Yes, I do.
Thank you.
Okay, with that, Mr. McDonald, you are okay to go ahead and commence your presentation.
All right, thank you, Mr. Baza. Again, their resumes were submitted as Exhibit 1 in this matter. I also want to confirm that you received the supplement to Exhibit 28 yesterday, which is simply the return receipts of the certified mailings of the requests that were made to the parties compulsory pooled, that we have known addresses.
I believe the board secretary did receive those.
Thank you. The board and by designation, the hearing examiner have jurisdiction over this matter pursuant to Utah Code annotated section 40-6-6.5 and the implementing regulations found in R649-2-8A and R649-2-9A. A copy of the request was mailed certified mail to the known parties sought to be compulsory pooled and mailed regular mail to all of the production interest owners within the drilling unit at their last addresses disclosed by the relevant realty records and OVINTIV's internal records, and also to the Ute Indian Tribe, the Ute Distribution Corporation, the Bureau of Indian Affairs, Utah Agency, and the Vernal Field Office of the Bureau of Land Management, which serves as the technical advisor to the Bureau of Indian Affairs, due to the tribal and allotted mineral ownership. Also, it was mailed to the Utah Department of Transportation and the Utah Division of Forestry, Fire, and State Lands due to the state being UDOT mineral ownership within the drilling unit. In addition, notice of the filing of the request in this hearing was duly published in the Uinta Basin Standard on September 25th, 2024, the Deseret News on September 27th, 2024, and in the Salt Lake Tribune on September 29th, 2024. On October 9th, 2024, the Division of Oil, Gas, and Mining filed a response expressing no opposition to the granting of the request for agency action, and no other objections or responses to the request were timely filed. This cause involves the compulsory pooling of the drilling unit established for the Lower Green River Wasatch production, comprised of the entirety of sections 6 and 7 of Township 4 South, Range 2 West, in Duchesne County. That's reflected on Exhibit 3. I don't know if we have that available. There we go. Thank you, Mr. Yeah, it's reflected, that's Exhibit 3. As you can see, the drilling unit is between the Bridgeland community and the Mutton Town site in Duchesne County, and it's intersected by US 40. As reflected on Exhibit 4, both sections 6 and 7 are irregular sections comprised of lots and quarter sections. The drilling unit is therefore comprised of 1,286.19 acres. The drilling unit was established by the board order entered in cause number 139-150, a true and correct copy of which was submitted as Exhibit 2 in this matter. OVINTIV is the majority working interest owner as reflected in revised Exhibit 7 and in paragraph 15 of Mr. Burns' declaration. Prior to the entry of the 139-150 order, Section 7 was not spaced. As outlined in paragraph 2 of the request and paragraph 9 of Mr. Burns' declaration, and is reflected in Exhibit 5, as shown on the screen right now, Newfield Production Company, which was OVINTIV's predecessor by merger and name change, drilled the identified existing wells, the vertical wells shown in Section 7. Production allocation for these wells was on a wellbore basis pursuant to the rule of capture. The 139-150 order provides that production from the existing wells would convert to the Section 6 and 7 drilling unit basis on the first of the month following the date of first production of the first long lateral horizontal well, being a well in excess of 1 mile, drilled on the drilling unit, and that any further recoupment owned from a non-consenting owner in the existing wells would be waived as of that time. In accordance with the 139-150 order, Newfield drilled, and OVINTIV now operates, the Colorado 1H well at issue, shown here also on Exhibit 5, with first production on August 30th, 2018, all is outlined in paragraph 6 of the request and paragraph 13 of Mr. Burns' declaration. The conversion date for the existing wells therefore was September 1st, 2018. As outlined in paragraph 9 of the request for agency action and paragraph 15 of Mr. Burns' declaration, numerous other working interest owners in this drilling unit have executed joint operating agreements, thereby voluntarily pooling their interests. As shown on Exhibit 6A, the Utah Department of Transportation, or UDOT, owns an unleased interest in the drilling unit. However, the Division of Forestry, Fire, and State Lands on its behalf has ratified the recorded pooling declaration, therefore voluntarily pooling UDOT's interest with the other fee leases. There are 7 specific parties to be compulsory pooled and declared as non-consenting owners in the Colorado 1H well. These are Larry Allen Walker and Kayla Lee Walker, successor trustees of the Catherine H. Walker Family Living Trust, dated April 5th, 2012, as amended and restated, which I will refer to as the Walker Trust. Colt Huber, Kara Schultz, Loretta Huber, Tracy Lee Markham Sherrill, Dennis S. Noble, and Mary Ellen Slemiker Benion. As reflected in Exhibits 9, 11, 13, 14, 17, 19 through 22, and paragraphs 19, 20, 22, 23, 25 through 27 of Mr. Burns' declaration. The requisite notices of opportunity to participate in the Colorado 1H well were provided to all of these parties except Kara Schultz, but none timely responded. As addressed in paragraph 15 of the request, paragraph 21 of Mr. Burns' declaration, and as reflected in Exhibit 12 and Replacement Exhibit 23, Kara Schultz was provided her notice of opportunity to participate in the Colorado well by publication in the Uinta Basin Standard on September 25th, 2024 and October 2nd, 2024, but she too failed to timely respond. As addressed in paragraph 18 of Mr. Burns' declaration, subsequent to the filing of this request in the exhibits, Julian Lucero, Lynn Huber, Monette Tapia, also known as Monette Lee Noble, and Emily Lazima, formerly known as Emily Noble, as trustee of the Noble Family Trust dated June 22nd, 2002, all leased to OVINTIV. As a consequence, OVINTIV moves to amend the request to eliminate these parties, and exhibits 8, 10, 15, and 18 will not be submitted for admission into evidence as a result. Revised Exhibit 7 does reflect the previously unleased gross working interest of these parties as being credited now to OVINTIV, and conversely, the reduction of the gross working interest of those parties to be compulsory pooled. In addition, just yesterday, OVINTIV received a lease from Vincent C. Noble, who was also named to be compulsory pooled in the request. As a consequence, OVINTIV also moves to amend the request to eliminate Mr. Noble, and Exhibit 16 will not be admitted into evidence. Since the lease was just received, revised Exhibit 7 does not account for the increase in OVINTIV's gross working interest and the reduction of the compulsory pooled gross working interest, being Mr. Noble's 0.001353% as outlined in paragraph 24 of Mr. Burns' declaration. If it is your desire, Mr. Baza, we will file a second revision to Exhibit 7 to update those figures, if that's your request.
I think we'll need that for the board hearing.
And we'll be happy to file that tomorrow. In addition, although OVINTIV believes it has leased all successors and voluntarily pooled their interests pursuant to the pooling clauses contained in their leases, and is otherwise expressly identified in the request to be compulsory pooled, there may be additional parties claiming by, through, or under certain decedents, as identified in paragraph 28 of Mr. Burns' declaration, with one addition he will address shortly, whose estates have not been probated or are incomplete in distribution of the mineral interest in the drilling unit. Pursuant to the board's order entered on September 16, 2024, and is reflected in Replacement Exhibit 23, the requisite notice of opportunity to participate was provided to these unknown parties by publication on September 25, 2024, and October 2nd, 2024. No responses to that publication notice was received. Replacement Exhibit 23 in this cause is a true and correct copy of the affidavit of publication of the notices of opportunity to participate received from the Uinta Basin Standard. As reflected on Exhibit 24 in paragraph 33 of Mr. Burns' declaration, the average weighted fee royalty, is 19.019322%, which was calculated at the time the well was spud. It does not include the Indian lease or the state royalty amounts. As outlined in paragraph 34 of Mr. Burns' declaration, the parties shown on the certificate of service filed in this cause are all of the production interest owners in the subject drilling unit. Their names and addresses were derived from a title opinion from a Utah licensed title attorney with an effective date in 2023, as supplemented by the record search by OVINTIV's contract landmen and OVINTIV's internal records. Exhibit 28 as supplemented reflects the status of the certified mailings of the request to those parties expressly named to be compulsory pooled and for which no valid addresses were discovered. As the record will reflect, none of the parties in the request for agency action is being compulsory pooled and or is declared as non-consenting owners in the Color Row well have timely filed a response or have made an appearance today. Consequently, pursuant to Utah Administrative Code R641-113-100 and R641-108-400, OVINTIV moves to enter an order of default against them, and we would ask that you rule on that at this time.
Mr. White, do you have any concerns about
No objection.
that? Very well, an order of default is correct.
Thank you.
Accept that.
As reflected in Exhibit 25 and paragraph 5 of Mr. Wall's declaration, the costs incurred in the drilling of the Color Row well were reasonably and necessarily incurred and within reasonable variance of the AFE that was sent out. As outlined in paragraph 6 of Mr. Wall's declaration, the estimated plugging and abandonment costs for the Color Row well is $75,000. Exhibits 27 and 28 in paragraphs 7 and 8 of Mr. Wall's declaration outline the risks assumed at the time of the spud of the Color Row well. With that, I'll commence my examination of Mr. Burns at this time. Mr. Burns, would you please state your name and business address for the record?
Yes, Peter Burns, and OVINTIV's address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas 77380.
What is your current position with OVINTIV and how does it relate to this drilling unit?
I'm a land advisor over the Uinta asset with responsibility over this drilling unit, among others.
Would you please state for the record the corporate and bonding status of OVINTIV?
Yes, OVINTIV is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of OVINTIV Production, Inc.
All right, would you confirm for the record that exhibits 3 through 6, revised exhibit 7, exhibits 9, 11 through 14, 17, 19 through 22, and 24 were prepared by you or OVINTIV personnel or contractors with your review and input?
Yes.
Would you also confirm for the record that replacement exhibit 23 is an official business record of OVINTIV?
Yes, it is.
All right, Mr. Burns, have you had an opportunity to read, and will you confirm for the record that all the statements made in your declaration are true and correct, or if any modifications are required, please state them on the record?
Yes, it is true and correct with a couple modifications. We need to identify and add Jeffrey J. Noble to the list of decedents in paragraph 28 of my declaration. He was identified in the errata to the RAA as a deceased party and is listed as such in the published notice, but his name was inadvertently omitted from the declaration. Additionally, as Mr. McDonald stated, Vincent C. Noble has now leased to OVINTIV as well. Instead of those reflected on revised Exhibit 7, OVINTIV gross working interest in the drilling unit should now be 98.607026%, and the compulsory pooled gross working interest should be 0.0551893%.
Finally, Mr. Burns, is it your expert opinion that the terms and conditions of the joint operating agreement submitted as Exhibit 22 are fair and reasonable and consistent with those executed by the other working interest owners in this drilling unit as outlined in paragraph 15 of your declaration, and with those commonly accepted by industry and in particular in the Uinta Basin with respect to horizontal well operations?
Yes.
Mr. Baza, that concludes my examination of Mr. Burns, and he's open for questioning by the division and yourself.
Okay. Mr. White, does the division have any questions first?
The division has no questions.
Okay. I know that I've already issued an order of default. I'm curious, for my own purposes, how does that affect decedent parties?
If there is a party claiming by, through, or under them, then they are in default as well.
Okay.
And if and when they're identified, they would be deemed as non-consenting owners in the drilling unit and subject to a risk assessment penalty if you award that.
So I'm assuming, since we haven't heard from anyone, a probate hearing has not occurred yet.
No, not in the interim that we're
So
aware of.
does this affect the court's decision in probate, or is this totally separate?
No, the mineral interest is still owned by that party, but it's up to the court to decide who those parties may be.
Okay. Gotcha.
It does not divest them of their interest.
All right. And of course, those parties would still get their weighted land over.
That's correct, if and when they're identified.
All right. Thank you very much. Let me ask I guess, Mr. Burns. So have you reviewed your declaration then, and is that your testimony in this matter?
Yes, it is.
And do you have anything to add to that at this point, other than those modifications that you've already stated?
No, just I'll just say that we will provide an updated revised Exhibit 7 that shows the new working interest calculations after Mr. Noble's lease was submitted yesterday.
Okay. Thank you, Mr. Burns. That's all I have.
Can I just clarify one thing, Mr. Baza?
Oh, yes.
The copy that I have of Mr. Burns' declaration is missing page 7.
It's actually out of order.
Oh, it's
Check
just out of
above
order.
page 6.
Yeah.
Check up. Oh, there we go. Okay.
Apologies, probably
I
got
have it.
scanned in the wrong way.
No, that's okay. I just want to make sure we had it for the record.
Thank you. All right, with that, I'll commence my examination. Mr. Wall. Mr. Wall, would you please state your name and business address for the record?
Christopher Wall, 4 Waterway Square Place Drive, Suite 100, The Woodlands, Texas 77380.
And what is your current position with OVINTIV, and how does it relate to this drilling unit at issue?
I am a reservoir engineering advisor with jurisdiction over this DSU as well as others in the Uinta Basin for OVINTIV.
All right, would you confirm for the record that exhibits 25 through 27 were prepared by you or OVINTIV personnel with your review and input?
Yes.
All right, and would you confirm for the record that you've read, and can you confirm all the statements made in your declaration are true and correct? Or if any modifications are required, please state them on the record.
Yes, they are true and correct and do not require any modifications at this time.
All right, is it your expert opinion that the actual costs of the Color O well at issue reflected in Exhibit 25, which is shown on the screen right now, were fair and reasonably and necessarily incurred?
Yes.
Is it also your expert opinion that the Color O well was economically feasible to drill, as that term is utilized in the 139-150 order?
Yes.
Finally, is it your expert opinion that the risks shown and outlined on exhibits 26 and 27 justify the imposition of a 300% risk assessment award and is fair and reasonable under the circumstances?
Yes.
Thank you. Mr. Baza, that concludes my examination. Mr. Wall.
Mr. White, any questions for Mr. Wall?
No questions.
Okay. I don't have any questions for Mr. Wall either.
With that, Mr. Baza, that concludes our presentation in chief. At this time, I would move for admissions of exhibits 1 through 6, revised exhibit 7, which will be again revised per your request. Exhibits 9, 11, 12 through 14, 17, 19 through 22, replacement exhibit 23, and exhibits 24 through 27 and 28 as supplemented, as well as Mr. Burns and Mr. Wall's declarations. Just for the note, the exhibits 8, 10, 15, 16, and 18 are not being submitted for revision based on the leases that were obtained from the parties involved in those exhibits.
Understood. Did you catch all that, Julianne?
Any objections from the division?
No objection to the admission of the exhibits.
So admitted.
With that, Mr. Baza, I'll reserve any closing remarks unless the division, after the division makes its statement.
Okay. Let's go ahead and go to the division for any comments or statements.
The division has reviewed the requests for agency action as well as the exhibits and declarations. And after hearing the presentation today, has no objections and agrees that this request should be granted.
And I should mention that I did see the division's response and notice of non-oppositions. Thank you for that. And let's go to petitioner, Mr. McDonald.
Thank you, Mr. Baza. With that, the statutory and regulatory requirements for the granting of the request have been satisfied. The requested relief is fair, reasonable, and justified. And we ask that the request be approved as submitted. We thank that your time and attention for consideration of this matter, and also the DNR staff for the participation virtually by the witnesses.
Sir, were you here for any of these? You know which one?
Is this the OVINTIV meeting?
This is OVINTIV and this is for the cholera well.
I have an interest in a 140-acre parcel that they're drilling on. That's my interest.
Okay, can you identify the location of that parcel?
Yes.
Cause number 132-59.
You say that, I guess.
59.
No.
Cause 132-59.
So that is yours.
Yeah, if you want, we can check. It's up in a few minutes. We can chat for a few minutes.
So Mitch, let me ask you, Mr. Mayo, what did you find out from the previous one?
It's for another matter, and I'll update you when that matter comes up, just so we don't call this one.
Okay,
On both those.
all right. Why don't you go ahead with Mr.
Thank you.
Mayo?
That's Council Brogan.
All right, having cleared that up, let's see, we're down. All right, trying to move this along fairly quickly. Having reviewed the request for agency action, the exhibits that have been admitted, and considering the evidence presented here today, I find that OVINTIV has provided sufficient notice of opportunity to the non-consenting CP owners, and that those owners identified in the request for agency action did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geologic conditions present with these wells. Find that it would be appropriate to impose the requested non-consent penalty. I find that OVINTIV has met its burden of proof to show that it is entitled to forced pooling of the named interest and other relief requested in the request for agency action. I will say that I am unavailable next week for the board hearing, so my legal advisor and counsel will be presenting the hearing examiner's recommendation at the board meeting. Mr. McDonald, will you prepare a proposed order?
I will, Mr. Baza, and I'll make sure both counsel for yourself and the division review it ahead of time.
Okay. Any other comments in this matter before we close? If not, we'll adjourn this proceeding. Thank you for all the parties today. Thank you, staff. I appreciate the people who helped with the electronic means of having this hearing. There's a lot of staff work that goes on behind the scenes on these matters, and I just want to express appreciation and acknowledge all that effort. Thank you so much. This matter is adjourned.
Thank you.
Thank you.
If they're, are they leaving right now?
Mr. Burns is leaving. Mr. Wall will be on the next.
I have a question for Mr. Burns, I believe.
If it will help, I will give you my hearing outline.
It was one of his answers. No, maybe it wasn't. Okay, never mind. I think you're good. Sorry about that.
And we can certainly work with you later. for
Yeah.
Terminology that you may have.
Yeah. Well, there was one word I didn't hear at all, so
Okay,
we'll figure it out.
thank you so much.
And yes, I would love your outline, sir.
Yes, just make sure I have your information.
Perfect.
With that, we're going to move through this as quickly as possible. We're now on item 2 on the hearing examiner's agenda. Phoebe, are you okay? Do you need a break? or anything?
I'm good. If they're all this long, like 3 of them at a time is probably fine.
We'll take a break after the third matter now. Okay, good morning, everyone, and welcome. My name is John Baza. I have been appointed by the Board of Oil, Gas, and Mining as the hearing examiner in this proceeding. Today is Wednesday, October 16, 2024. And this is the time and place for the hearing examiner's proceeding for docket number 2024-057, cause number 132-56, in the matter of the request for agency action of OVINTIV USA Inc. for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Peckapovitz UT 1-14 4-3-12-1-7H well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch formations comprised of all of sections 1 and 12, Township 4 South, Range 3 West, USM, Duchesne County, Utah. Holding this hearing with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. And before we begin, are there members of the public present for this matter or respondents for this proceeding that wish to comment? Seeing none, we'll continue. I'll take appearances of counsel at this time.
Fred McDonald of Counsel with Lear and Lear on behalf of Petitioner OVINTIV USA Inc.
For the division.
Assistant Attorney General Gary White for the Division of Oil, Gas, and Mining.
Okay, and I'll mention again that Mr. Carter Moore, seated next to me, he is Assistant Attorney General who will be advising me in this matter. With that, I will mention that I have received declarations from Mr. Ashley Ellison, Mr. Christopher Wall in this matter, and I see that they're both present and ready to testify in this matter. Does the division have any objections to the declarations or the declarants being qualified as experts in this matter?
No objection.
Okay, so with that, Mr. Ellison and Mr. Wall, you are recognized as experts in your particular field of expertise for this matter. And I think we're ready to have those witnesses sworn in at this time.
Again, for the record, testifying virtually pursuant to the board's order entered yesterday are Mr. Ashley Ellison, who is the senior land negotiator for OVINTIV, Mr. Christopher Wall, who's the reservoir engineering advisor for OVINTIV. Mr. Ellison's been recognized by you as an expert in petroleum land management, and Mr. Wall is an expert in petroleum engineering for purposes of this cause. And would you please swear them in as witnesses at this time?
Gentlemen, can you please raise your right hand, both of you? Thank you. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I'll start with Mr. Ellison.
Yes, ma'am, I do.
And Mr. Wall.
Yes, I do.
Let's go ahead with your presentation, Mr. McDonald.
Thank you, Mr. Baza. Again, the resume of both witnesses were submitted as Exhibit 1 in this matter. The board and by designation, the hearing examiner have jurisdiction over this matter pursuant to Utah Code Annotated, Section 40-6-6.5, and the implementing regulations found at R649-2-8A and R649-2-9A. A copy of the request was mailed certified mailing to the known parties sought to be compulsory pooled, and mailed regular mail to all other production interest owners within the drilling unit at issue at their last addresses disclosed by the relevant realty records and OVINTIV's internal records. This included the Ute Indian Tribe, the Ute Distribution Corporation, the Bureau of Indian Affairs, Uinta and Ure Agency, and the Vernal Field Office of the Bureau of Land Management, who served as technical advisor to the Bureau of Indian Affairs due to the tribal and allotted mineral ownership within the drilling unit. It was also mailed to the Utah Department of Transportation, or UDOT, and the Division of Forestry, Fire, and State Lands due to the state being the UDOT mineral ownership within the drilling unit. In addition, notice of the filing of the request in this hearing was also duly published in the Uinta Basin Standard on September 25th, 2024, the Deseret News on September 27th, 2024, and in the Salt Lake Tribune on September 29th, 2024. On October 9th, 2024, the Division of Oil, Gas, and Mining filed a response expressing no opposition to the granting of the request, and no other objections or responses to the request were timely filed. This cause involves the compulsory pooling of the drilling unit established for Lower Green River Wasatch production, comprised of the entirety of sections 1 and 12 of Township 4 South, Range 3 West in Duchesne County. That drilling unit is shown on Exhibit 3. Again, the drilling unit is located pretty much halfway between the Bridgeland community and the Mighton Town site, and is again bisected by US 40. As shown on Exhibit 4, Section 1 is an irregular section comprised of 16 different lots. Accordingly, the drilling unit is comprised of 1,292.78 acres. The drilling unit was established by the board's order entering cause number 139-150, and is reflected in Exhibit 7, revised Exhibit 7, and in paragraph 11 of Mr. Ellison's declaration. OVINTIV is the majority working interest owner in the drilling unit. A true and correct copy of the 139-150 order was submitted as Exhibit 2 in this cause. In accordance with the 139-150 order, new field drilled and OVINTIV now operates the Pekapovitz 7H well at issue here, with first production on October 16, 2018. All is outlined in paragraph 3 of the request and paragraph 10 of Mr. Ellison's declaration. As shown on Exhibit 5, it is the only well currently located within the drilling unit. As outlined in paragraph 6 of the request for agency action and paragraph 11 of Mr. Ellison's declaration, numerous other working interest owners in the drilling unit have executed joint operating agreements, thereby voluntarily pooling their interests. As shown on Exhibit 5, you can see there is a small tract owned by UDOT, which remains unleased, but the Division of Forestry, Fire, and State Land has agreed to execute a pooling declaration voluntarily pooling UDOT's interest with the fee leases. There is one other working interest owner which requires compulsory pooling, which I will address shortly. There are 27 specific parties to be compulsory pooled and declared as non-consenting owners in the Pecapovich 7H well. I'll list these just for the record. Ann Stevenson, Anne Marie Sorensen, Brian Sweeney, David A. Sorensen, Diane Wright, Gary Young, HC Ridgeside Energy Partners LLC, which I'll refer to as HCR, Jack Nyman, John C. Rhodes, Joyce Pullman, Carolee Dennett, Kate S. Fowler Markham, Lee C. Brockbank, Gary H. Brockbank, and Julia C. Kalidi, co-trustees of the W. Hughes Brockbank Living Trust dated May 8th, 1991. I will refer to them as the Brockbank Trust. Lyle Young, Marty M. Murray, Mark Young, Mary Ellen Slemaker-Benion, Misty Allred, Merlene Stansfield, Uinta Mineral Holdings, Inc., which I'll refer to as UMH, Arch Uinta LP, which I'll refer to as Arch, Scott Tierlink, Stephen Tierlink, Susan Johnson, Tracy Lee Markham Sherrill, Virginia Trumbull Smith, trustee under agreement dated October 30th, 1974, which I will refer to as the Smith Trust, and W. LeGrand Young. As reflected in Exhibits 8, 10 through 18, 20, 21, 23 through 28, 30 through 35, and 42, which you received last week, and paragraphs 14, 16 through 24, 26, 27, 29 through 34, and 36 through 40 of Mr. Ellison's declaration. The requisite notices of opportunity to participate in the Pecapovich well were provided to all of these parties except Anne Marie Sorensen, the Brockbank Trust, Mark Young, and Susan Johnson, but none formally and timely responded, except as I will now address. Outlined in paragraph 39 of Mr. Ellison's declaration, HCR subsequently did lease to OVINTIV, but the lease is limited to the Pecapovich 7H well only. Its remaining interest in the drilling unit as relevant to future development remains unleased. It failed, however, to respond to the terms of the joint operating agreement proposed by OVINTIV as required under Rule R641-2-8A. As such, it is no longer considered a non-consenting owner in the Pecapovich 7H well, but must still be compulsory pooled as to its remaining unleased working interest and also the imposition of the joint operating agreement as proposed. As addressed in paragraphs 15, 25, 28, and 35 of Mr. Ellison's declaration, and as evidenced by exhibits 9, 19, 22, and 29, and replacement exhibit 36, Anne Marie Sorensen, the Brockbank Trust, Mark Young, and Susan Johnson were also sent notices of opportunity to participate in the Pecapovich well to their last known addresses, but were either unclaimed or undeliverable and returned to OVINTIV. Pursuant to the board's order entered on September 16, 2024, they were also provided their notices by publication in the Uinta Basin Standard on September 25, 2024, and October 2nd, 2024, but they too failed to respond. As addressed in paragraph 32 of Mr. Ellison's declaration, Uinta Mineral Holding and Arch also responded to OVINTIV, indicating they would lease, but no leases from them have ever been received. In addition, although OVINTIV believe it has leased all such successors and voluntarily pooled their interest pursuant to the pooling clauses contained in said leases, except as to any parties specifically identified in the request to claim through one of the estates and is to be compulsory pooled, there may be additional parties claiming by, through, or under certain decedents as identified in paragraph 41 of Mr. Ellison's declaration, whose estates have not been probated in Utah or are incomplete in distribution of the mineral interest in the drilling unit. Pursuant to the board's order entered on September 16, 2024, the requisite notices of opportunity to participate were provided to them by publication on September 25th, 2024 and October 2nd, 2024. No responses to those published notices were received as well. Replacement Exhibit 36 in this cause is a true and correct copy of the affidavit of publication of the notices of opportunity to participate received from the Uinta Basin Standard. As reflected on Exhibit 37 and paragraph 46 of Mr. Ellison's declaration, the average weighted fee landowner's royalty as of the date of spud of the Pekopovich 7H well is 19.118884%. And again, the Indian leases and the state royalties are not included in that calculation per the statute. As outlined in paragraph 47 of Mr. Ellison's declaration, the parties shown on the certificate of service filed in this cause are all of the production interest owners in the subject drilling unit. Their names and addresses were derived from a title opinion dated effective as of January 9th, 2018, is supplemented by a record search by OVINTIV's contract landmen and OVINTIV's internal records. As the record will reflect, none of the parties identified in the request as being compulsory pooled and declared as non-consenting owners in this cause timely filed a response or have made an appearance today. Consequently, pursuant to Utah Administrative Code R641-113-100 and R641-108-400, OVINTIV moves to enter an order of default against them, and we ask that you rule on that at this time, Mr. Baza.
Yes, order of default is appropriate. I agree.
Any
Do you
objections?
have any questions?
No objection.
Thank you. As evidenced by Exhibit 38, which is shown on the screen and is outlined in paragraph 5 of Mr. Wall's declaration, the actual costs of the Pekopovich well were reasonably and necessarily incurred and were within reasonable variance of the AFE that was sent out. As outlined in paragraph 6 of Mr. Wall's declaration, the estimated plug-in and abandonment cost for the Pekopovich well is $75,000. Finally, as shown on Exhibits 39 and 40, and as addressed in paragraph 7 and 8 of Mr. Wall's declaration, they outline the risks assumed at the time of the spud of the Pekopovich well. With that, I'll commence my examination of Mr. Ellison. Mr. Ellison, would you please state your name and business address for the record?
Yes, sir. My name is Ashley Ellison. Business address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas 77380.
What is your current position with OVINTIV and how does it relate to this drilling unit?
Sure. I'm a senior land negotiator. Gave myself a promotion there. With responsibility for this drilling unit as well as others.
All right, would you please state for the record the corporate and bonding status of OVINTIV?
OVINTIV is a Delaware corporation in good standing with its principal place of business for Rockies operation in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company by merger of OVINTIV Production.
Okay, Ashley, if you could just stay close to your mic because sometimes you're fading out on the record. Did you get everything? Okay, all right. Would you confirm for the record that exhibits 3 through 6, revised exhibit 7, 8 through 35, 37, and 42 were prepared by you or OVINTIV personnel or contractors with your review and input?
Yes, sir. That's correct.
Would you also confirm for the record that replacement exhibit 36 is an official business record of OVINTIV?
That is correct as well.
All right. Would you also confirm for the record that you have read and confirm and can confirm all the statements made in your declaration are true and correct? Or if you have any modifications, please state them on the record at this time.
I have, sir, and no modifications.
Finally, is it your expert opinion as an expert in petroleum land management that the terms and conditions of the joint operating agreement submitted as Exhibit 35 are fair and reasonable and consistent with those executed by the other working interest owners in this drilling unit and those commonly accepted by industry and in particular the Uinta Basin with respect to horizontal well operations?
That is correct as well.
Mr. Plaza, that concludes my examination. Mr. Ellison?
Mr. White, do you have questions?
Yeah, Mr. Ellison, if you could go to paragraph 39 of your declaration, I believe it's on page 12. That's where you outline the more recent negotiations with HCR.
Yes,
You
sir.
with me?
Yes, sir.
Great. Could you provide a little bit more explanation about what happened here with HCR agreeing to lease as to the well, but not to the unit?
Yeah.
And then- yeah, go ahead.
Yeah.
Go
No
ahead.
problem. So we've been, HC Ridgeside is another entity of Arch, UT 1808. They're non-op interest owner, mineral owner in a lot of our DSUs.
I'm missing so much of what you're saying.
Just slow down a little bit, Ash.
Yeah, no problem. So
Would you mind starting over?
that is fine. I'm happy to. HC Ridgeside is one of the entities of Arch, UT 1808, UT Holdings. They have lots of names. They are a mineral owner in a lot of our DSUs. We've been working on them with them for a year or so, attempting to lease their interest. And in this instance, this entity wanted to simply lease their wellbore interest. I don't know necessarily why only wellbore. I guess they wanted to retain their ability to participate in the future. But we were able to get a lease for this interest in the wellbore. Much like every unleased owner in our DSUs, we could simply lease the interest, or if they would like to participate, that is completely fine as well. In this instance, they only lease their wellbore interest, and therefore we need to impose a JOA for the future development to pool it.
What's the last two words?
Pool their interest.
For the future development to pool their interest.
Yes.
Thank you.
Sorry, that was a long explanation.
No, I appreciate that. Hold on just a second.
Yes, sir.
Could you just provide a little bit more explanation? When you say they only lease their wellbore interest, what does that mean as opposed to the unit as a whole?
Sure. In any unit in our, in our DSUs, future development potential is anywhere from 4 wells to 12 to 18, depending on the formations we drill. In this instance, we've drilled 1 well in this DSU. So they have elected to lease their interest in this 1 well. For future wells, we will send them the necessary participation paperwork. And then at that point, they can elect to participate in those future wells, or we will work out a lease to lease their interest in those future wells.
Got it. And with regard to the JOA, have they specifically rejected the proposed JOA, or you just haven't received a response?
We haven't really received a response. We have worked with these entities in a lot of other DSUs. They have no problem with our JOA. They have signed our JOA in the past. I think they're just kind of hard to pin down. I've been working with them, and Peter Burns, our other landman, has been working with them for a number of years. They've signed our JOA in the past, so this is not an issue of they don't like the language in it.
Got it. Okay, that's all the questions. Thank you.
Yes, sir.
Mr. Plaza, could I redirect a question to Mr. Ellison?
Yes,
Thank you.
please.
Mr. Ellison, would you also confirm that you did send a proposed joint operating agreement covering the entire joint drilling unit? Is that correct, to HCR?
That is correct.
And you didn't receive any response within 30 days regarding those terms, rejecting those terms, or proposing additional terms, is that correct?
That is correct.
Thank you.
Yeah, I have one follow-up question, which is based on things that the division asked. If I understand this correctly, if the board approves the compulsory pooling, they will be imposing a JOA on HCR. Is that just for the well, or is that imposition of the JOA for the entire drilling unit?
It's for the entire drilling unit.
Is that
And-
correct?
But
I
they
will-
will have an election by election basis. Go ahead, Ash, I'm sorry.
Yeah, and I will say that the same JOA that is imposed in this hearing is the exact same JOA that they have signed, this entity has signed for other units. So there is no difference. The difference is they just didn't respond in this instance.
So if they have the choice to participate in future wells, they'll elect to do that. Will they be subject to that JOA that we're posing at this point?
Yes, that is correct.
Just wanted to clarify that.
Right, but they do have an election on each well in the future.
Understood. Okay, those are all my questions.
All right, thank you. With that, I'll start my examination of Mr. Wall. Mr. Wall, would you please state your name and business address for the record?
Yes, my name is Christopher Wall. Business address 4 Waterway Square Place Drive, Suite 100, The Woodlands, Texas, 77380.
And what's your current position with OVINTIV, and how does it relate to the drilling unit as issued?
I am a reservoir engineering advisor for OVINTIV with jurisdiction over this DSU as well as others in the Uinta Basin.
All right, would you confirm for the record that exhibits 38 through 40 were prepared by you or OVINTIV personnel with your review and input?
Yes,
All right, would you also confirm for the record that you've read, and can you confirm that all of the statements made in your declaration are true and correct? Or if any modifications are required, please state them on the record at this time.
yes, they are true and correct and do not require modification at this time.
All right, is it your expert opinion that the actual cost of the Pekapovich 7H well at issue as reflected on exhibit 38, which is shown on the screen, were fair, reasonable, and necessarily incurred?
Yes,
Is it also your expert opinion that the Pekapovich 7H well was economically feasible to drill, as that term is utilized in the 139-150 order?
yes,
Finally, are the risks shown on exhibits 39 and 40, in your expert opinion, justify the imposition of a 300% risk assessment award? Is that fair and reasonable under the circumstances of this well?
yes.
That, Mr. Baza, that concludes my examination, Mr. Wall.
Mr. White, do you have any questions for Mr. Wall?
No questions for Mr. Wall. Thank you.
I don't have any questions either.
All right, thank you, Mr. Baza. That concludes our presentation in chief. At this time, I would move for admission of exhibits 1 through 6, revised exhibit 7, exhibits 8 through 35, replacement exhibit 36, and exhibits 37 through 42 inclusive, as well as Mr. Ellison's and Mr. Wall's declarations.
Any questions or objections, division?
No, no objection.
We'll admit all those.
All right, thank you. I'll reserve my closing remarks after the division statement.
Okay, it's time for closing statements. We'll start with the division.
Thank you, Mr. Baza. The division has reviewed the request as well as the submitted exhibits and the declarations, and upon hearing the evidence today has no objection to the granting of this request. Thank you.
And again, we have received the response of the division, notice of non-opposition, who were filed All right, Mr. McDonald, go ahead.
Thank you, Mr. Bowser. With that, again, the statutory and regulatory requirements for the granting of the request have been satisfied. We believe that the requested relief is fair, reasonable, and justified, and we ask that the request be approved as submitted. Again, we thank you for your time and consideration, and also thank the DNR staff for the virtual appearance by the witnesses, making it pretty easy.
Thank you, Mr. McDonald. All right. Having reviewed the request for agency action, the exhibits that have been admitted, and considering the evidence and testimony presented today, I find that OVINTIV has provided sufficient notice of opportunity to the non-consenting CP owners, and that those owners identified in the request for agency action did not timely elect to participate in the wells, and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geologic conditions present these wells. And I find it would be appropriate to impose the requested non-consent penalty. I find that OVINTIV has met its burden of proof to show that it is entitled to forced pooling of the interest and other requested relief in the request for agency action. I will state that I'm not available for next week's hearing, so Mr. Carter Moore, legal counsel, will provide the hearing examiner's recommendation to the board at that time. So with that, Mr. McDonald, would you prepare the proposed order?
I will, Mr. Bowser, and I'll make sure the council, both for the division and Mr. Moore, get it for your review in time.
Okay, thank you very much. Any other comments from division or any other parties in the room? Very well. With that, we will adjourn this proceeding. Thank you very much. And thank you to all the staff and again for the electronic participation we were able to have.
Thank you, everyone.
Thank you.
I actually think it's an invasion of the attorney-client privilege. I object.
Not all. But signing into the internet here, you make it clear. Dates and shine.
How we can be fired up.
All right, I'm trying to join that meeting link unless somebody wants to work for me.
Good job, you.
That part.
I'm ready. I'm ready when you are.
Yuri, you still biking in?
Not today.
Not today.
I don't like to bike in a suit.
You might lose your
That's fair.
opportunities to bike in the next. Because it's supposed to turn winter.
I bike in the winter as long as it's not snowing.
You're coming in from Farmington?
Well, I cheat. I bike to the train and then,
Oh,
yeah, so So it's only about 12 miles round trip. It's nice. Yeah.
I didn't
On
expect
these,
you to
on
like
these special
that.
days, I usually just drive.
Maybe you had your biking shorts.
Yeah, they're on.
You're holding his suit jacket.
He's got biker shorts on below the desk.
Exactly.
That's right. That's right. Need to get some of those insulated stretch chairs. Oh, yeah. Well, I have shorts, but I don't have the winter.
I don't know that I've heard from Mr. Dale.
You may not have, if you recognize him, he's the one clean shaven head. But he's one of their managers of their land department.
I wonder if we need to do any additional
He's been
qualification.
qualified as an expert for 4 or 5 times.
Hey Mitch, can you tell OVINTIV to buy Ash's own computer so he doesn't have to use his wife's computer?
That's his wife's. His first name's Ashley, his middle name's Laura.
I see the picture.
We got that.
Okay.
He's not here to defend himself.
He is there, he's listening. These microphones pick up
Exactly.
I don't have ready, I'm not gonna pull up exhibits because there's an issue, but if we need to look at anything, just holler. Exactly. I've got it.
We know your presentations aren't as slick as.
And everybody goes.
Luckily, he makes it very clear.
No, I have the exhibits, so we should be done. At least you save them directly from PDF from Word to PDF, so they look nice. We appreciate that.
There's a lot of ways to skin a cat.
But scanning,
Some people have their
scanner
favorites.
should not be one of them.
I'm with you, man. It's all right.
Solid.
Okay. I think we're ready. Paul, is that right?
Yes.
Okay, I think we're ready when you are. David, are you? Oh, there you are. Can you hear us okay, David?
Yes.
Oh, good.
Mr. Holst.
I'm ready whenever you are.
Go. You're good?
Yeah.
All right, we'll move on to item number 3 on the hearing examiner's agenda. Good morning, everyone. Welcome. My name is John Baza. I have been appointed by the Board of Oil, Gas, and Mining as the hearing examiner in this proceeding. Today is Wednesday, October 16th, 2024. This is the time and place for the hearing examiner's proceeding for docket number 2024-062, cause number 132-59. In the matter of the request for agency action of OVINTIV USA Inc. for an order pooling interests, including the compulsory pooling of interests of certain non-consenting owners in the PECAV, I believe that's correct.
Fair enough.
UT 2-29, 3-1-29-32-1H well identified in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch formations, comprised of all of sections 29 and 32, Township 3 South, Range 1 West, USM, Duchesne County, Utah. We're holding this hearing with an anchor position in the Department of Natural Resources Building in Salt Lake City, Utah. And let me ask, are there any members of the public participating in this matter?
There's a member of the public here that I've discussed the matter with. I don't know if he's going to be participating, but I'm going to be at least giving an update on his concerns in the discussion, and he'll be welcome to raise any concerns after.
Very well. Participate as you need to. Could you identify yourself for the record?
John Kerner, Koerner.
Thank you very much. Let's go ahead and take appearances of counsel.
Thank you, Mr. Baza. Mitch Mayo, Lear and Lair, PLLC, on behalf of OVINTIV USA Inc. petitioner.
Assistant Attorney General Gary White on behalf of the Division of Oil, Gas, and Mining.
And seated next to me is Mr. Carter Moore, Assistant Attorney General, who will be providing me with legal counsel on this matter. Okay, I've received declarations from Mr. David Dale and Mr. Christopher Wall in this matter, and I've reviewed them for this hearing. Before we go any further, I'm going to let Mr. Mayor, you introduce your witnesses.
Thank you. And probably appropriate to have them sworn in at the time as well. With us is Mr. David Dale, a manager for Rockies Land at OVINTIV. David, could you raise your hand? And Mr. Christopher Wall, Reservoir Engineer Advisor for OVINTIV. Do we have them sworn in at this time?
Can you please both raise your right hand? Thank you. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Mr. Dale, you first.
I do.
Mr. Wall.
Yes, I do.
Thank you.
Okay, having had them sworn in, their declarations and their resumes are included as part of the information packet for this matter. Division, do you have any objections if we recognize these witnesses as experts?
No objections.
Okay. Therefore, they are recognized as experts in their particular field of expertise, which I'm sure Mr. Mayo will provide that information as we go forward.
I'm happy to.
Okay, let's go ahead.
Thank you, Mr. Boss. I appreciate that. I'm going to try and truncate some of this presentation because I think the more important part is the questions asked by the hearing examiner and division. But I'll get through what we have to get through. Obviously, with us today are Mr. Dale and Mr. Wall, the two witnesses. As Mr. Baza just recognized, Mr. Dale is an expert in petroleum land management for purposes of this hearing. And Mr. Wall is an expert in petroleum or reservoir engineering for purposes of this hearing. As also was mentioned, their declaration testimony was filed. I believe yesterday was the date of filing, maybe the 14th. And both of them are present here to verify and answer any questions related to that testimony. The board and the hearing examiner have jurisdiction over this matter pursuant to Utah Code 40-6-625 and the implementing regulations. I'd like to note this is a somewhat unique matter. OVINTIV is only seeking to pool estates in this matter. All of the named owners have been located and voluntarily committed to this unit. Regardless of just pooling estates, OVINTIV has provided legal and lawful notice to all parties required to it, including to relevant federal and tribal agencies as required under Utah law. In addition, I'd just like to note that notice was published in the Uinta Basin Standard on September 25th, Deseret News on the 27th, and the Salt Lake Tribune on September 29th of this year. The division filed a non-opposition on October 9th, pending the presentation here today, and we believe that will satisfy their concerns, if any. One last note, there are no other objections of record here today. As mentioned, this cause involves the pooling of a unit established under the 139-134 order. This unit comprises sections 29 and 32 in Township 3 South, 1 West. It's a standard 1280 unit, and OVINTIV is the majority interest owner, as demonstrated on Exhibit 7 and is testified to in Mr. Dale's declaration. A copy of the relevant order, 139-134 order, was submitted as Exhibit 2. OVINTIV, pursuant to that order, spud the subject well, the PECAV, just my guess of how to say it, PECAV UT 2-29 3-1-29-32-1H well, which I will call the PECAV 1H well, or the subject well. That was spud on November 17th, 2017, and first production was on February 16th, 2018. At the time the request was filed and the well was drilled, there were no wells producing from the subject land. So conversion and recoupment, as you usually hear about in these, are not an issue. As I mentioned, this is somewhat unique because 100% of the interest has elected to participate. However, there are a number of estates where distribution is incomplete, such that those estates need to be pooled here today to be doubly sure that all who have an interest are a part of this development. To make sure that all parties who are a part of this development are pooled. I don't know what I said, so I'm just making.
Can you try looking like more straight ahead? Once you turn your face, I can hear you way like less.
Okay, you can, okay, I'll try to look at you actually, because you're the one who needs to hear. Notice was published to try to apprise each of these estates and any heirs or successors thereof of this request and of their election to participate in wells. Exhibit 17 on file is an affidavit of that publication. No responses were received to that publication here in this matter. Also, as reflected on Exhibit 11 and discussed in Mr. Dale's declaration, the acreage weighted fee landowner's royalty for this PECIF 1H well is 18.430221%. Finally, notice was provided to all production interest owners as reflected in the certificate of mailing on file. With that, I think it's probably appropriate to jump right into Mr. Dale's testimony. Mr. Dale, can you please state your name and business address for the record?
Yes, David Dale, manager for Rocky's Land at OVINTIV with a business address of 4 Waterway Square Place, Suite 100, Woodlands, Texas, 77380.
Okay, and you mentioned you're the manager of Rocky's Land. Are you in charge of the drilling unit, or do you have any sort of supervisory role over the lands at issue here in this matter?
Yes.
Okay. I'd just like to quickly confirm some of your declaration testimony. First of all, are you aware of the declaration? I believe it was filed as exhibit number 15 in this cause, the declaration of David Dale. Have you seen that declaration?
Yes.
And have you reviewed all the allegations in it?
I have, yes.
Did you execute or cause your counsel to execute that declaration on your behalf?
Yes.
Okay. And can you confirm that the allegations contained in the declaration are true and correct?
Yes.
Okay. Last question, I guess. Does the declaration constitute your full and complete testimony here today?
Yes.
Okay. One sum up, in your expert opinion, do the terms and conditions of the JOA submitted as Exhibit 8, are they fair and reasonable and appropriate to be applied in this cause?
They are, yes.
Okay. With that, I have no further direct questions for Mr. Dale, pending any sort of follow-up from the hearing examiner or division.
Mr. White, do you have questions?
The division doesn't currently have questions, but may have questions after we hear from the witness or the person from the public who's with us.
I'm happy, if now is a good time, I'm happy to kind of give an update. Mr. Kerner and I spoke prior to this hearing. He's one of the, we mentioned that all production interest owners receive a copy of this. He happens to be one of those production interest owners who received a copy of it. It's just estates in this pooling, and Mr. Kerner confirmed to me that he's not a descendant that he's aware of to any of these named estates. So really, I think Mr. Kerner was here primarily to kind of learn about the process and see if any questions could be answered, but also to kind of follow up with me and maybe with OVINTIV about the status of his minerals and where to go from here. If that's fair, you can nod or add anything.
Yes, that's correct.
Okay. Thank you.
Mr. Kerner, thank you for being here, making the trip. This is a complicated process. Sometimes it goes over my head.
Yes, sir.
But it is great to have members of the public show up and participate, and I agree. So appreciate that. But that was the gist of it, and I think we're gonna catch up offline after this hearing and answer any questions he has.
Thanks for that, Mitch. I did have a question, and it's similar to one that I asked in a previous matter. Because we're dealing with the states, I'm assuming no probate action has been taken at this point.
That I'm aware of, or that OVINTIV's aware of, no. At least no Utah court probate action.
So if one does happen, that will identify any specific mineral estate that then needs to be compensated.
That's right. In the earlier matter, I think the question was largely about whether the probate court can still make the decisions it needs to. Yes, obviously the probate court can distribute any of these estates if requested by one of the heirs. They have the ability to do it. OVINTIV is bound by court orders like anyone else. So if they're presented with a probate order, they absolutely will change their decks. David, tell me if I'm speaking out of turn. OVINTIV will follow a valid probate order and change your decks appropriately.
We would, yes. Yeah, this is simply to guarantee that we have all the working interest parties that could own identified, or I guess have that working interest secured for OVINTIV to move forward that interest.
So is there a royalty interest that continues, and is that escrowed at this point?
Well, it's not escrowed because as of today, OVINTIV's position is 100% of the owners are participating in some way. They made their election. But in case one of these estates, let's just pick one. The first one on the list is the estate of James Weston. If next month James Weston's heirs go in and get a probate order, and it turns out that the 3 heirs that OVINTIV thought were the heirs of the James Weston estate, there's actually a 4th heir. That 4th heir will be pooled under the order here today and will get the acreage weighted royalty that is subject to this year. The other 3 heirs are subject to their leases that they've executed with OVINTIV or whoever.
But they've executed what? I can
With
barely hear you.
OVINTIV, that's okay.
But they've executed with
Yeah, period.
OVINTIV?
Well, it doesn't matter. With OVINTIV or whoever, but executed is good.
I'm just trying to, and Mr. Dale can answer this, but I'm just trying to make sure that potential royalty owners don't lose their percentage share in this somehow.
Yeah.
Yeah.
No. David, go ahead.
Okay. Yeah, no, that's correct. Whether, they're an existing owner that we have leased and their interest through probate is increased or decreased, they still get a royalty. We would just follow that interest allocation on the increase or decrease. If they are a new heir that we had not previously leased and we go through probate and we learn about them, then they would still be subject to the forced pooling and get the average weighted royalty. And, to the extent they're identified, then OVINTIV would likely pursue them to secure a lease for future oil and gas wells with them. The fact of the matter is we just have no certainty we've identified all of the heirs or the correct heirs with the correct ownership.
Okay. Thank you. I think I understand and appreciate that explanation. I think we're ready to proceed with your next witness, Mr. Mayor.
Okay. Mr. Wall, can you please state your name and business address as well for the record?
Yes, Christopher Wall, 4 Waterway Square Place Drive, Suite 100, The Woodlands, Texas, 77380.
Okay, and state your job title with OVINTIV and kind of your responsibilities generally and with respect to this unit.
Yes, I'm a reservoir engineering advisor for OVINTIV with jurisdiction over this DSU as well as others in the Uinta Basin.
Thank you for that. Mr. Wall, are you aware of what's been filed as Exhibit 16 in this cause, the declaration of Christopher Wall?
Yes,
Did you execute this declaration or cause your counsel to execute it on your behalf?
yes,
Okay. Are you familiar with the allegations in the declaration?
yes,
And would you say the declaration reflects your full and accurate testimony here today?
yes,
Okay. A couple of clarifying questions for your, you've been recognized as an expert here in petroleum reservoir engineering. Is it your expert opinion that the actual costs of the Peckham 1H well, as reflected in Exhibit 12, were fair, reasonable, and justified?
Yes.
Okay. Is it your expert opinion that those costs were within a reasonable variance of the estimated costs in the AFE submitted as Exhibit 10?
Yes.
Okay. Is it your expert opinion that the risks discussed in Exhibit 14 and as addressed in your declaration, paragraphs 8 and 9, do you believe, in your expert opinion, those justify the risk compensation award of 300%?
Yes.
Okay. With that, I have no further direct questions for Mr. Wall, subject to any cross-examination.
Mr. White, do you have any questions at this time?
Yeah, in Exhibit 14, you talk about the drilling and operational challenges. You mentioned that there was increased drilling time due to fishing stuck drill pipe. Do you have any more details about that you could share?
So the intervals that we drill from time to time can stick pipe. It's actually, well, I don't want to say fairly common, but it's more common than some other basins that I've worked. And this happens from time to time where, you know, as we're drilling in a lateral or in a curve, the pipe will get stuck. And there's many different reasons for that. But in this particular case, it looks like it was stuck just after the curve, somewhere in the beginning of the lateral, and did require us to draw on it for a couple of days to break it free, and we were able to recover it.
Okay. Did that result in substantially increased cost for the well costs?
It does increase the well costs, one just for time, but also increased rental tools. We have to use specialty tools that we don't have typically on a drilling rig. So those have to be brought into the basin sometimes, which does increase our cost.
Okay. All right, that's it. Thank you.
With the division's questions, I don't have any additional questions for Mr. Wall.
Perfect. With that, I will quickly sum up. I think it's probably appropriate to move for admission of Exhibits 1 through 17 in this cause. Mr. Botha?
Is that it?
Accepted.
Oh, yes.
Those exhibits for filing?
Do you have any objection?
No objection.
Thank you.
Those are admitted.
Finally, full notice was provided. There were no objections or protests. And we believe that the statutory and regulatory requirements have been met, and that the relief requested is both fair and reasonable, but also that it's justified based on the facts in this case. And we ask that the RAA be approved as pleaded.
Okay. Very well, and thank you for the previous submittal of the exhibits and declarations. Those are very helpful. And so I'll go ahead and finish my comments at this point. Having reviewed the request for agency action, all the exhibits, and considering the evidence presented here today, I find that OVINTIV has provided sufficient notice of the opportunity of non-consenting CP owners, and those owners did not timely elect to participate and should be deemed non-consenting at this time. I find that 300% non-consent penalty is fair and justified given the economic and geologic conditions present with the well, and find that it would be appropriate to impose the requested non-consent penalty. Find that OVINTIV has met its burden of proof to show that it is entitled to forced pooling of the named interest and other relief requested in the request for agency action. And with that, Mr. Mayo, I will ask you to prepare the proposed order. Just to state again, I will not be present in next week's hearing, so Mr. Moore, my legal counsel, will present the hearing examiner's findings and recommendations to the board.
I'm happy to do a draft of that and I'll circulate it to council for them to look at.
Thank you very much.
Thank you.
Any other comments, Mr. White? Any other parties? All right, with that, we'll adjourn this matter. And I believe we have to change over some material in the room. Thank you again to staff. This is a lot of work behind the scenes. And I can't express my appreciation more for the work Ms. Carter does and the electronic people do to make all this happen. So thank you again.
Thank you. You want to do a 5-minute recess while we swap out hearing examiners?
Yeah, whenever Mr. Rogers is prepared to take over and start.
Thanks, David. You're done for the day.
Good morning. My name is John Rogers, and I'm an environmental manager with the Utah Division of Oil, Gas, and Mining. I have been appointed by the Board of Oil, Gas, and Mining to act as a hearing examiner in this proceeding. Today is Wednesday, October 16th, 2024, and this is a time and place for the hearing examiner proceeding for docket number 2024-061, cause number 132-58. In a matter of the request for agency action of OVINTIV USA Inc. for an order pulling interest, including compulsory pulling of the interest of certain non-consenting owners in the PCAV Utah 2-29 3-1-28-33-7H well identified herein, the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch Formation, comprised of all the sections 28 and 33, Township 3 South, Range 1 West, Uinta Special Meridian, Duchesne County, Utah. We are holding this hearing in an anchor position in the Department of Natural Resource Building in Salt Lake City, Utah. We also will be hearing testimonies and presentations in person and virtually, and the proceedings will be broadcast on the internet. I wish to thank the division staff, the legal counsel, petitioners, and the department technical staff for allowing these proceedings to go forth both remotely and in person. Before we begin, are there any members of the public who are interested and would like to comment on these proceedings?
Yes. My name is Carl Mangum, and I'm an attorney, and I represent Donald Reed and Julianne Reed. They are the trustees of the Julian Pike Reed Family Trust, and mainly here for just observing and making sure that our understanding is correct of what's happening.
Okay, thank you. All right. Let the record show, and we got that name down and everything there. Okay, appreciate that. We'll now take appearance of counsel this time. Petitioner?
Thank you. Mitch Mayo of Lear and Lear, LLC, on behalf of the petitioner, OVINTIV USA Inc.
Division?
Assistant Attorney General Gary White for the Division of Oil, Gas, and Mining.
My counsel is Emmy McKay, seated to my left, and she's at the Attorney General's office. Some procedural items at this time. I have received declarations from Mr. Ashley Ellison, Senior Land Negotiator for OVINTIV USA, and Mr. Christopher Wallace, Senior Reservoir Engineer Advisor for OVINTIV USA Incorporated for this matter. I have read both of them before this hearing. Both these witnesses have been accepted as expert witnesses for past hearings. Does the division have any objection to these declarations, or are these individually qualified as expert witnesses?
No objection.
Okay. They will be recognized as expert witnesses in this particular field of study for work on this matter. Mr. Mayo, are the witnesses present today?
They are. They're both here and available.
Can we swear them in at this time?
Can you please both raise your right hands? Thank you. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Mr. Ellison first.
Yes, ma'am.
Thank you. Mr. Wall?
Yes.
Thank you.
Okay, we'll now proceed to Mr. Mayo for his presentation.
Thank you for that introduction, Mr. Rogers. I'm trying to skip through some of the stuff that was already discussed so I don't repeat the great introduction. So I may just jump in here. The board and the hearing examiner have jurisdiction over this matter pursuant to Utah Code 40-6-6.5. A copy of the request in this matter and the relevant pleadings filed therewith were sent certified mail to the known parties sought to be compulsory pooled and sent by regular mail to all other production interest owners within the drilling unit. These mailings were sent to the last addresses disclosed by the relevant realty records and by OVINTIV's internal records and searching. In addition, the request was mailed to all the relevant federal and tribal and state agencies as required under Utah law, including in this cause CITLA, BLM, and BIA. In addition, notice of the filing of the request and this hearing was also duly published in the Uinta Basin Standard on September 25th, Deseret News on September 27th, and the Salt Tribune on September 29th of this year. On October 9th, the division filed a response expressing no opposition pending the presentation here today. No other objections or responses to the RA were filed in this cause. However, we did have a couple of folks who reached out and contacted us regarding their interests, and I'll discuss those in a minute and have Mr. Ellison available to answer any follow-up questions about that. As mentioned, this cause involves the pooling of a unit established under the 139-134 order. It's an irregular 1,280.70 acre drilling unit that comprises sections 28 and 33, Township 3 South, Range 1 West in Duchesne. OVINTIV is the majority interest owner in this unit, as shown in Exhibit 8 and amended Exhibit 8 filed yesterday as well to address the removals that we'll discuss here. Pursuant to the 139-134 order, a copy of which was submitted as Exhibit 2.
Mitch, can I ask one thing right now? I may have missed that new exhibit. Is there any way we could pull that up?
It was filed yesterday. Yes, I think it's essentially the working interest summary, and because there's parties that have leased during
Yeah, I
this,
figured that
it
was
just changes
changed.
the percentage.
Okay.
So I'll make sure you get a copy if you haven't gotten a copy.
I may have, but this all got yesterday and I had a lot to go through, so I
I'm
may
with
have
you, and
missed
I apologize for that. Yeah, so we'll.
Okay, so let's, Emily has it here, let me see. So I had 99.21, now it's 99.97. Okay, great.
Okay, sorry, thank you for that. Pursuant to the 139-134 order, OVINTIV spud the PECIV UT 2-29 3-1-28-33-7H well, which we'll either call the PECIV 7H or the subject well. That well was spud on November 15th of 2017 with a date of first production of February 18th the next year, 2018. At the time the PECIV 7H well was drilled and at the time the request was filed, there were no wells producing from the subject lands. So conversion and recoupment as provided for in the 139-134 order are not an issue in this cause. As mentioned, there were several owners named to be pooled as having refused or failed to lease, and there were several estates also named to be pooled on pages 2 and 3 of the request. However, since the request was mailed out, a few of those folks have reached out and clarified their interest, or at least their interest. And I'll go through those with you now. So there's been two of the estates have reached out. One of them for kind of an unusual reason, and one of them for a fairly standard reason. The first is the estate of Bryant Buckwalter. OVINTIV's searching had led them to the conclusion that Mr. Buckwalter had passed away. It turns out he's very much alive. He called me and we talked. So he was removed, as he also has leased his interest to International Petroleum, who was sent a JOA and they've signed it and returned it.
At least beforehand?
Whether it was beforehand or after, he reached out to us and said, I'm alive and I've leased my interest.
Okay.
So we've removed him from the pooling, and International Petroleum has received JOA. It's my understanding they've signed it and returned it.
Are they planning on being a working interest on it, or just?
They have participated in signing the JOA, it's my understanding. And so the estate of Bryant Buckwalter has been removed. Second, there was another estate, the estate of Julian Reed. You heard from Mr. Carl Mangum, who's here from the public representing the Reed estate. The Reed estate was named to be pooled for kind of lack of evidence of sufficient distribution. And in addition, several named Reeds were named as parties to be pooled. Deborah Reed, Donald E. Reed, Judy Reed Thomas, Julianne, but it's spelled Juleann, one word, Reed, Julian G. Reed, and then Julianne Reed and Donald E. Reed as co-trustees of the Julian Pike Reed Living Trust. Those individuals were all named to be pooled as well. However, their interest flowed solely from the estate of Julian Pike Reed. Long long story short, Mr. Mangum reached out, his clients reached out, provided sufficient proof of distribution and of leasing. At this point in time, the estate of Julian Pike Reed and all of the named Reed heirs that I just discussed have all been removed from the pool based on the satisfaction of the documents provided to OVINTIV.
Can I ask a question that I was thinking about as this was read in the previous hearing? They said they only leased the well bore. I don't understand that, because all the results can be the same as if they lease their minerals, isn't it?
Well, yes and no. I mean, as a mineral owner, like H.C. Ridgeside, they can choose in that prior matter, they can choose to lease their interest in the entire unit, or they can choose to lease a specific part. I lease just this part or just this part, and they've chosen just to lease their wellbore. And really, if you think about it, it gives them the ability to go back in and negotiate next time.
Okay,
if
so
someone wants to drill.
there were no, as I looked through here, and you stated earlier, there were no wells drilled before this. This is the first well, correct?
That's right.
So is this in that well bore we're talking about?
This is a different matter from the H.C. Ridgeside. There are no, at least as far as I'm aware, there's no wellbore.
This is the same family. So this guy that was here is not connected. Okay, I got it.
This guy that was here wasn't connected to H.C. Ridgeside.
Okay, I thought, okay.
H.C. Ridgeside was a different company that was discussed as part of their election. The man you're talking about, his name is John Kerner, and he was just a mineral interest owner who had questions.
Okay.
This is Carl Mangum represents the estate of Julian Pike Reed.
Okay,
As
sorry
far
for
as
the
I know, they're
confusion.
not related to any of those parties. Good question. Aside from these parties that have been removed, the parties named in the request are still appropriate to be pulled here today. As reflected on Exhibit 21 and as discussed in paragraph 27 of Mr. Ellison's declaration, the acreage weighted royalty for this well is 19.380608%. Notice was provided to all production interest owners in the subject unit, as outlined and discussed in Mr. Ellison's declaration and in the certificate of service on file. Finally, costs, including plugging costs, are just and reasonable, and the risks incurred in drilling the subject well justify the imposition of a 300% risk compensation award. With that, I'm going to move on to Mr. Ellison's testimony. Mr. Ellison, you can hear me all right?
Yes, sir, I can.
Okay, would you please state your name and business address for the record?
No problem. My name is Ashley Ellison. Business address is 4 Waterway Square Place, Suite 100, The Woodlands, Texas 77380.
Okay, and what is your position with OVINTIV and your responsibilities in that position generally and with this unit?
Sure. I'm a senior land negotiator for OVINTIV, and I'm with responsibilities for this DSU as well as others.
Okay. You're aware of what's been filed as, let me make sure I got the number correct, Exhibit 25 in this cause, the declaration of Ashley Ellison?
I am, sir, yes.
Okay. And have you reviewed and are you familiar with all the allegations contained in the declaration?
Yes, sir, I am.
Okay. Did you execute or cause your counsel to execute this declaration on your behalf?
That is correct.
Okay. Can you confirm on the record that the testimony provided in that declaration is your full and complete testimony here today?
It is. That is correct.
Okay. One last kind of question before I sum up with your expert opinion. I discussed the removals of the parties here today, the estate of Brian Buckwalter, the estate of Julian Pike Reed, and the named Reed heirs. Can you confirm that those have been removed and that OVINTIV is planning to treat them as voluntarily committed to this well?
Yeah. Yes, I can confirm that. This is, in a perfect world, this is exactly how this would work. We send notices out, and then if we hear nothing back, we start the forced pooling process. At that time, if anybody gets our notifications, we would love to lease people rather than do this. So the Reeds reached out in our our broker was able to lease the estate. So this is how this should work. And it would be wonderful if the same thing happened to the other individuals that we are now forced pooling. So I just wanted to kind of state that.
Okay, thank you for that. So aside from the estate of Brian Buckwalter and the estate of Julian Reed and the Reed heirs, no one else has been removed from this pooling as far as you know.
That is correct.
Last question, in your expert opinion, are the terms of the JOA both fair and reasonable and also justified to impose in this unit?
Yes, sir, they are.
Okay, and with that, I have no further questions for Mr. Ellison, subject to cross.
Thank you, Mr. Mayo. Division, would you have any questions?
We don't have questions. Thank you. Thanks for the explanation. You addressed everything.
Yes, sir.
Okay, we'll proceed to your next witness.
Thank you for that. Stick around, Mr. Ellison. We may have a follow-up for you here. Mr. Wall, can you please begin by stating your name and then just confirm whether you have the same business address as Mr. Ellison?
Yes, name is Christopher Wall, and I have the same business address as Mr. Ellison.
Thank you for that. And what is your job title and responsibilities with OVINTIV as it relates to this unit?
Yes, I'm a reservoir engineering advisor for OVINTIV with jurisdiction over this DSU as well as others in the Uinta Basin.
Okay. I want to confirm your declaration testimony. Are you aware of and have you seen what's been filed as Exhibit 26, the Declaration of Christopher Wall?
Yes.
Okay. Are you familiar with the allegations contained therein? Did you review them all?
Yes.
Okay. Did you execute the declaration or cause your counsel to execute it on your behalf?
Yes.
And does the declaration as conform to your testimony here today reflect your full and accurate sworn testimony?
Yes, it does.
Okay. A couple of questions to sum up on in your expert opinion, Mr. Wall. Are the actual costs of the PECAV 7H well as reflected in Exhibit 22 on file, are those fair, reasonable, and necessarily incurred?
Yes.
Okay. And do you believe those costs on Exhibit 22, the actual costs, are within a reasonable variance of the AFE estimated costs?
Yes.
One last question. In your expert opinion, do the risks discussed and identified in Exhibit 24 and as discussed in your declaration, paragraphs 8 and 9, do you believe those justify the 300% risk compensation award requested in this cause?
Yes.
Okay. With that, I have no further direct questions for Mr. Wall.
Division, you have a question for this witness?
We have no questions. Thank you.
Just one point of clarification, and I may have missed this earlier, but the landowner royalty rate will change with the removal of these individuals. It won't.
No, that's a good question. The reason it won't is because the landowner royalty rate is calculated at the time the well spun. So any leases that are in hand as of February 2017 are calculated into that age-rated royalty calculation because these leases were taken last week. They aren't part of the age-rated royalty.
So that number is fixed at time of spud.
That's right.
Okay, thank you. The division has filed a response of notice of non-opposition to request for the agency access dated October 9th, 2024. Therefore, it's my understanding the division has no objection to the request for agency action, but reserves the right to update its response after receipt of evidence and cross-examination during this proceeding. Is that accurate, Mr. White? I'll turn the time over to the division for their presentation.
So the division has reviewed the request for agency action as well as the exhibits, the declarations, and based on the presentation today has no objection to granting this request. Thank you.
Okay, we'll take closing statements at this time. And the first will begin with Mr. Mayo.
Thank you. Simply like to remind all that full notice was provided. There were no objections or protests. Two parties who reached out to us concerning their interests both had their interests addressed to their satisfaction, and I believe Mr. Mankin would speak up if not the case. Statutory and regulatory requirements have been satisfied, and the request of relief is fair, reasonable, and at this time almost an ordinary course of action. And we would ask that the REA be approved. Before I make that formal request, though, I should probably move for admission of exhibits. Specifically, exhibits 1 through 7. What was filed yesterday as amended exhibit 8, I believe. And exhibits 9 through 28.
So admitted. No division. You have a problem with that?
No objection.
So admitted.
Thank you for that. And so, yeah, on that basis, I'd like to submit and ask the request be approved.
Do you have any more to add, Mr. White, for the division?
Thank you.
Admitted exhibits, so let's move forward with my summation. Having reviewed the request for agency action, all exhibits, and having considered the evidence presented here today, I find OVINTIV has provided sufficient notice of opportunity to non-consenting compulsory pooled owners, and that those owners identified their request for agency action did not timely elect to participate in the well, and therefore should be deemed non-consenting parties. I find a 300% non-consent penalty is fair and justified, given the economic and geological conditions present with this well, and find that it would be appropriate to impose a requested non-consent penalty. I find that OVINTIV has met its burden of proof to show that they are entitled to enforce pulling the named interest and other relief requested in a request for agency action. Mr. Mayo, will you prepare a proposed order?
I have a question, Your Honor.
Sure.
Sorry. I would like it stated on the record, or you state on the record that the Julian Pike Reed and their heirs have been removed from this order. Would that be correct, Mr. Mayor?
That's correct. Yeah, it's of the record in the declaration testimony, and the witness testified to it, but I don't think Mr. Rogers has confirmed that. To the extent you'd like him to, sure.
I can confirm that, and that will be with that'll be recorded. Okay.
Next Wednesday's hearing, October 23rd, will be when the order from today's hearing is formalized, and you should see that hearing fair and quarterly removed.
Can you just make sure to circulate the draft order to council?
Every once in a while, we have a motion, then things happen, and in the final draft, things that happen aren't put into.
That's exactly right. The good thing about this,
into the order.
The good thing about this is the filings have already happened for evidence. So at this point, if we tried to accidentally put the Julian Pike Reed estate back in, there wouldn't be evidence to support it. But we will make sure that's in there. And once division and hearing examiner have approved the order, if it's okay, I'll send.
You have his
Mr.
contact?
A courtesy copy.
Thank you very much.
You're welcome. Okay. Yes, I do.
Okay. Does the division have your name and address also?
I'll circulate it.
Okay.
After this. Is that
She has it here.
okay?
All right, thank you. I then, next week, will present the findings and conclusions to the board at the board hearing. Are there any other comments we have before we close? Okay. Anyway, I thank you for your participation, and we'll adjourn this proceeding.
Ash, Chris, you guys are done for the day. Thanks.
Thank you all. Appreciate it.
All right, we've got 4 XCL.
Mark Grave, can we get a sound check from you, please? Mr. Grape, can we get a sound check, please?
Yes, can you hear me?
Yes, thank you. Mr. Hanson, can we get a sound check, please?
Check 1, 2, 3.
That sounds great. Thank you very much.
Good morning. My name is John Rogers, and I'm Environmental Manager with the Utah Division of Oil, Gas, and Mining. And I have been appointed by the Board of Oil, Gas, and Mining to act as a hearing examiner in this proceeding. Today is Wednesday, October 16, 2024, and this is a time and place for the hearing examiner's proceeding for docket number 2024-065, cause number 132-60. In the matter of the request for agency action of XCL Resources LLC on behalf of XCL Asset Company LLC for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 2,560 acre or substantial equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch Coal formations comprised of Section 28, 29, 32, and 33, Township 2 South, Range 2 West, Uinta Special Meridian, Duchesne County, Utah. We are holding this hearing with the anchor position in Department of Natural Resource Building in Salt Lake City, Utah. We will also be hearing testimonies and presentations in person and virtually, and the proceedings will be broadcast on the internet. I wish to thank division staff, legal counsel, petitioners, and the department technical staff for allowing these proceedings to go forth both remotely and in person. Before we begin, are there any members of the public or respondents present who wish to comment on these proceedings? We have not received any electronic desire to proceed, and we have no one.
And I haven't been contacted.
Okay. Let the record show no public respondents are present. We'll now take appearance from counsel this time. Petitioner.
Thank you. Mitch Mayo of Lear & Lair PLLC on behalf of petitioner XCL Resources and XCL Asset Co LLC.
Thank you. Division.
Assistant Attorney General Gary White for the Division of Oil, Gas, and Mining.
My counsel is Emily McKay of the Attorney General's Office. I've received declarations for this matter from Mr. Kevin Anderson, Vice President of Development and Land, and Mr. Mark Grave, Executive Vice President of Reservoir, both of XCL Asset Company. I reviewed both of these declarations before this hearing. Both witnesses have been accepted as expert witnesses for past hearings, and at this time I'd like to ask the division if they have any objections to these declarations or these individuals being qualified as expert witnesses.
No objection.
Okay, thank you. They are recognized as experts in their particular field of study and work for this matter. Mr. Mayo, are these witnesses present today?
They are.
We swear them in at this time.
Gentlemen, can I have you both raise your right hand, please? Thank you. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? I'll do Mark first.
I do.
Thank you. And Kevin?
I do.
Thank you.
Okay, thank you. We can now proceed to Mr. Mayo for your presentation.
Thank you, Mr. Hearing Examiner. You've gone through a lot of the introduction, so I'll skip to a little bit of the middle here. The board and by designation, the hearing examiner have jurisdiction of this matter pursuant to Utah Code 40-6-6.5. A copy of the request in this matter was sent by certified mail to any known parties sought to be compulsory pooled and sent by regular mail to all other production interest owners within the drilling unit. Their last address is disclosed by the relevant realty records or by XCL's internal records. The request was also mailed to all relevant federal and tribal agencies as required under Utah law due to mineral ownership in the unit. Finally, notice was provided to certain owners via publication as authorized by this board on September 17th. In addition, notice of the filing of the request and this hearing was duly published in the Uinta Basin Standard on September 25th, Deseret News on September 27th, and the Salt Lake Tribune on September 29th. On October 9th, the Division of Oil, Gas, and Mining filed a response expressing no opposition pending the presentation here today. And there were no other objections or responses timely filed to this cause. To summarize this case, as Mr. Rogers said, this is a compulsory pooling request for a 2560 acre unit established under 600-04 order. This unit produces from sections 28, 29, 32, and 33 in Township 2 South, Range 2 West. In accordance with the order 600-04, XCL drilled and has begun to produce from the 3 wild wells identified in the request for agency action. Several owners of undivided oil and gas in the subject unit and the subject wells have refused or failed to lease or otherwise agree to pay their proportionate share of the costs of the well. And that includes the names of the folks on page 2 of the request for agency action. In addition, as discussed in Mr. Anson's declaration on file as Exhibit 11, several estates are named to be pulled in the request for agency action. Although XCL believes it has leased and voluntarily located and pooled all of the heirs and successors of those estates, without complete distribution, we can't be certain of that fact. XCL provided notice of opportunity required under Utah law to these potential heirs or successors of the estates via publication as authorized by the board in its order entered on September 17th. Exhibit 13 on file is an affidavit reflecting that opinion. Only one response material to this request was received through this process, and that was related to the estate of Jerry Deans. Jerry Deans was named as one of the estates, that's DEANS, was named as one of the estates to be pooled in this cause. However, subsequent to filing the request, XCL was presented with sufficient evidence of the distribution of Mr. Dean's estate and of the voluntary participation of his heirs and successors that the Dean's estate is removed. And that was noted in Mr. Anson's declaration and will be confirmed in the order as well.
Okay, I'm looking at his declaration and it says removed. It says see paragraph 29 below. So is that what I'm? Yeah, probably check that. Okay, that's the Dean estate. So he was the only one being removed out of the list. So therefore, that will change the percentage again of the number being pulled.
Well, usually estates don't get a percent that they're attributed with because it's unclear how much of their interest isn't already covered by something. Most of the time, the interpretation is, or the assumption is that the estate doesn't own anything left that isn't committed. This is just in case they do. So there shouldn't be any need to change any of the numbers based on the removal of Mr. Deans.
Okay.
Yeah, the average weighted royalty is already calculated. The Dean estate's already calculated in that.
But what I'm saying is, you know, I have on here, my numbers is 99.778096 owned by OVINTIV XCL.
And that shouldn't change.
That remains fixed then again. Okay.
Essentially, we just got proof from the Dean's estate that it had been distributed much the way that we had assumed it had. And so it was just that
the amount didn't change, it's just the people did.
And the people didn't even change. It was just we had a court order verifying that we were right in our assumptions.
Okay, thank you.
And leave XCL. Lastly, before I start with Mr. Anderson, as reflected on Exhibit 8 and discussed in his declaration, paragraphs 30 through 32, the acreage weighted fee landowner's royalty as of the date of the spud of the wild wells is 17.562333%. And with that, I'll start my examination of Mr. Anderson, who can address any questions about the Dean's estate you have. Mr. Anderson, can you please state your name and business address for the record?
Kevin Anderson, 600 North Shepherd Drive, Houston, Texas, 77007.
Okay, and what is your position with XCL as it relates to this unit?
I'm the Vice President of Business Development and Land, and I have responsibilities of all the subsurface operations along with surface operations on all these DSUs.
Okay, somewhat unusual, but unusual times call for unusual measures. Can I have you briefly explain how you actually don't own an interest in this drilling unit?
as it pertains to the acquisition of SM Energy.
Yeah, if you just kind of give the, kind of the level you're comfortable with, so everyone here is clear on kind of what's going on.
Of course. So as most folks have probably heard, we were acquired by SM Energy, and that acquisition closed on October 1st of 2024. So by the terms of the purchase and sale agreement, we are now operating under a TSA, temporary services agreement. So all business that we're doing are doing for SM Energy, and they now own the interest in these units. However, when they were drilled and completed, it was under XCL Asset Co's operations.
Just to clarify and make sure everyone here's questions are addressed ahead of time, it's safe to assume that all business records of XELs are now business records of SMs, at least as they relate to this hearing?
Yep, that's correct.
And any actions undertaken by XEL personnel in the months prior to this hearing can be assumed on this end to be deemed to be actions of SM Energy folks related to this cause.
Correct.
Okay, thank you for that.
Just one quick question. So do we need to, as we go forth here with the final order, do you need to recognize that transition?
We most likely will include a paragraph or two indicating the transition. So yeah, I don't know that it's necessary to answer your question, but I would imagine we will, just to try and clarify.
I think it's helpful.
Mr. Anderson, just real briefly, now that you've talked about your position, I'm assuming you're aware of what's been filed as Exhibit 11 in this cause, the declaration of Kevin Anderson?
That's correct.
Have you reviewed, are you familiar with all the allegations contained in the declaration?
That's correct.
And did you execute or cause your counsel to execute the declaration on your behalf?
Correct.
Okay. Finally, does your declaration constitute the full and complete and accurate testimony from you here at this hearing?
Yep, that's correct.
Okay. In your expert opinion, last question, are the terms, conditions of the JOA submitted as Exhibit 7 really fair, reasonable, and justified to be imposed in this cause?
Yes, that's correct.
Okay. With that, I have no further questions for Mr. Anderson, subject to cross.
Okay. Mr. White?
Yeah, Mr. Anderson, I think it's implied in your declaration and based on the presentation today, but at paragraph 29 of your declaration, you talk about the estate of Jerry Deans. Is it accurate to say that Mr. Dean's heirs are leased?
Yes, that's correct. We had listed them under the estate out of an abundance of caution. However, since we got the clarity from the Dean family that essentially verified what we had previously assumed, we were able to take them on.
Great. That's all I have for you. Thank you, sir.
No, thank you.
Okay, I have one thing I'm just curious about here. I'm looking under the exhibits, Exhibit 2, which is
spacing order.
The cause number 600-04. And it states in paragraph 6, there are 124 existing vertical, directional, or horizontal wells. I realize this area is a lot more than what you're looking at here. I'm wondering, are there 124? Are there any existing wells in this subject area?
I don't know off the top of my head, Mr. Anderson. Do you know if there were prior to these 3 wild wells? Well, no, I can answer this. There weren't any in this 2560 units. These were the first 3 wells drilled in this 4-section unit.
Okay, I just like to feel comfortable knowing where we're at. That's 124. I thought maybe some of those had been in there.
There may be, and likely were, and Kevin, you can confirm if this is true, additional wells drilled in the 1280s that are on either side of these wells. But those were drilled about the same time. Is that right? Oh,
We can't hear you.
We know that there was at least a well drilled by Axia. Then, like Mitch said, if it was a 2560, the obligations were always to ensure that we had wells drilled on either side. So I can look that up, but I can almost guarantee there are, but not 124 between those two.
There were horizontal long laterals producing an each 1280.
Mark, just a second.
Yeah, axial. Yep.
Okay, go ahead, Mark.
Yeah, just to clarify, there were existing long laterals producing in each 1280 prior to the production of this 2560, which I believe is what Kevin said, but just clarify.
Okay, so is there any conversion that will need to go on here?
No, those are exclusively in OVINTIV spacing orders that they have conversion. XCL doesn't, they have overlapping. So
Okay.
the 2560 unit that we're talking about now doesn't have any development in it, except for these 3 wells.
But it's the same land.
The two 1280 units that make it up have wells drilled, but they were drilled at the same time as this, except for the first well that Axia drilled in each unit.
So those wells will be shared upon that spacing order.
That's right.
And had nothing to do with this pooling. Okay, so I just like to get that clarified.
Yeah, OVINTIV, everything converts to payable on the new wells basis for XCL and basically most other operators in the basin. They just, whatever it's drilled as, it pays as, and you have to stay separate, kind of far enough away from the other units that you protect correlative rights.
Okay.
That you protect what?
Correlative rights.
Okay, the division has asked their question, so we'll move on.
Okay, Mr. Gravy, would you please state your name and confirm whether you have the same business address as Mr. Hanson?
Yeah, Mark Gravy, we have the same address as Kevin.
Okay. And can you please provide your job title and the responsibilities over this unit?
Sure. My title is Executive Vice President of Reservoir and Development, and I'm responsible for the spacing and design of the development of new wells in each drilling spacing.
I'm assuming you're also aware of what's been submitted as Exhibit 12, the declaration of Mark Gravy. Can you confirm that you recognize and have reviewed all the allegations in that declaration?
Yes, I can confirm that.
Did you sign that declaration or cause your counsel to sign it on your behalf?
Yes, I did.
Okay. Do you have any corrections you would like to make on the record to that declaration?
I do not.
Okay. So it's safe to say that that declaration constitutes your full and accurate, complete testimony here today.
It does.
Okay. Couple questions on your expertise as an expert in this matter. Can you confirm whether you believe the actual costs to drill and operate the wild wells as reflected in Exhibit 10 were fair, reasonable, and necessarily incurred?
I do.
And in your expert opinion, was each of the wild wells economic to drill as that term is utilized in the 600-04 order?
Yes, they were.
Okay. Finally, do you believe the risks that XCL encountered and assumed at drilling of the wild wells justify the 300% risk compensation award requested?
Yes, I do.
Okay. With that, I have no further questions for Mr. Gravy, subject to cross.
Mr. White?
Mr. Gravy, we've been tracking the movie references and we just want to make sure, is this a reference to Wild Thing from Major League?
It is, yes.
Okay, that's all I have.
And we'll move on.
If there's no questions from the hearing examiner, Mr. Gravy, probably appropriate to sum up. Before I do, I'd just like to move for exhibits.
So I think that I'm not giving do you have anything to present, Mr. White?
Are we at closings now?
Unless
Or are you
want to-
doing exhibits?
I was just gonna move for admission and then add, but I'll just move for admission and do my closing, then you can do yours if you like.
Sure.
Unless you have something.
Did you give an opportunity? You have anything to present as a?
No.
Okay, go ahead, Mitch.
So probably appropriate, Mr. Rogers, to move for admission of exhibits 1 through 14. And this includes the declarations of both Mr. Anderson and Mr. Gravy.
Okay. Any objections to that?
No objection.
Okay, this time we'll take your closing arguments then.
Were those accepted for?
Yeah, accepted.
Thank you. Closing arguments are simple. Statutory and regulatory requirements have been met, and the requested relief is fair and reasonable and more than justified in this cause. And on that, we'd ask that the RAA be approved as modified by the declaration testimony. And I'd just like to thank everyone for their time and attention to the matter.
Okay. Do you have anything to add, Mr. White?
No, other than the division has reviewed the materials, the exhibits and declarations, and upon hearing the presentation today has no objection.
Okay, having reviewed the request for agency action and all exhibits, having considered the evidence presented today, I find that XEL has provided sufficient notice of opportunity to the non-consent compulsory pool owners, and that those owners identified in the request for agency action did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geologic conditions present within these wells. I find that it'd be appropriate to impose that requested non-consent penalty. I find that XEL has met its burden of proof to show that they are entitled to forced pooling of the named interest and other relief requested in the request for agency action. Mr. Mayo, will you prepare a proposed order?
I'm happy to do that.
I will then present the findings and conclusions at the board next week at their board hearing. Any other comments before we close?
No, thank you.
Okay, and thank you for your participation, and we'll be adjourning at this time. Timing. What do you want to do with respect to the in Texas?
You guys tell me. I informed them, Kevin and Mark, that we're 12 o'clock when we started your time, 12:30 now. Trying to be sensitive to your work schedules and your hungry tummies. Do you guys want a lunch break? Do you want to push through?
I'm good. I mean, they're all pretty straightforward. So, I mean, they're all pretty much the same DSUs with 1280s and 2560. So I think we can, if Mr. White would give me some more softball questions like he gave Mr. Mark, I could get through them a little quicker.
No, sorry, you get the hard ones as the last.
Not a lunch break, but a walking around break. Okay. I don't mind.
Okay, so we take about 10 minutes?
We can do that, and then just the last three all together.
Yeah, that works.
Perfect.
Any of lunch, we're all right to push through?
Should we go to Burger King, just get a couple?
Oh.
All right, guys, we got a
Good idea.
5 to 10 minute break. Quarter. We're gonna walk around for a minute. You can stretch our legs. We'll be right back.
Okay, I'll just mute it. We'll be right here.
Thank you, guys.
Good morning. My name is John Rogers, and I'm environmental manager with the Utah Division of Oil, Gas, and Mining. I've been appointed by the Board of Oil, Gas, and Mining to act as a hearing examiner in this proceeding. Today is Wednesday, October 16th, 2024, and this is the time and place for the hearing examiner proceeding for docket number 2024-066, cause number 132-61. In a matter of the request for agency action of XCL Resources LLC on behalf of XCL Asset Company LLC for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting unknown owners within a 1,1280 acre or substantial equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch Colton formations, comprised of section 29 and 32, Township 2 South, Range 2 West, Uinta Special Meridian, Duchesne County, Utah. We are holding this hearing in the anchor position in Department of Natural Resource Building in Salt Lake City, Utah. We also will be hearing testimonies and presentations in person and virtually, and the proceedings will be broadcast on the internet. I wish to thank the division legal staff and counsel, petitioners, and department technical staff in allowing these proceedings to go forth both remotely and in person. Before we begin, are there any members of the public or respondents present who wish to comment on proceedings at this time? Showing none, we'll take appearance at council at this time. Mr. Mayo?
Thank you, Mr. Rogers. Mitch Mayo of Lear and Lair PLLC on behalf of the petitioner in this cause, XCL Asset Co. and XCL Resources LLC.
Division?
Assistant Attorney General Gary White for the Division of Oil, Gas, and Mining.
My counsel is Emily McKay of the Attorney General's Office. I've received declarations for this matter from Mr. Kevin Anderson, Vice President of Development and Land, and Mr. Mark Grave, Executive Vice President of Reservoir, both of the XCL Asset Company. I've reviewed both of the declarations before this hearing. Both witnesses have been accepted as expert witnesses for the past hearings. And does the division have any objection to these declarations or these individuals being qualified as expert witnesses?
No objection.
They are recognized as experts in their particular field of study and work for this matter. Mr. Mayo, can we swear in the witnesses at this time?
Yeah, that would be perfect. Thank you.
Gentlemen, please raise your right hand. Thank you. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Kevin first.
I do.
Thank you, Mark.
I do.
Thank you.
This time we'll turn the time over to the petitioner.
Thank you, Mr. Rogers. The board and by designation, the hearing examiner have jurisdiction over this matter today pursuant to Utah Code 40-6-6.5. And a copy of this request was sent by certified mail to any known parties sought to be compulsory pooled, and was sent by regular mail to all other production interest owners within the drilling unit. These mailings were all sent to their last known address of record disclosed by the relevant realty records or by XCL's internal records searching. The request was also mailed to all relevant federal, state, tribal agencies as required due to mineral ownership within the unit. And notice was provided to certain owners, including the unknown heirs or successors of the named estates via publication, as authorized by this board on September 17, 2024. In addition, notice of the filing of the request and of this hearing was duly published in the Uinta Basin Standard on September 25th, the Deseret News on September 27th, and the Salt Lake Tribune on September 29th, 2024. On October 9th of this year, the Division of Oil, Gas, and Mining filed a response expressing no opposition pending presentation of evidence here today. No other objections or responses to the request for timely filing. As noted, this cause involves the compulsory pooling of the drilling unit comprising sections 29 and 32, Township 2 South, Range 2 West. This was established under cause 139-140. In accordance with the 139-140 order, XCL drilled and has begun to produce from the 13 Chubbs and Taparoo wells identified in the request for agency action. Excuse me. There were were several owners named, owners of undivided oil and gas interests in the subject unit and the subject wells. These owners were named on page 2 of the request to be pooled because they either refused or failed to lease or otherwise pool their interests for common development. One of those named owners, Bradley Goodrich, presumed heir of Brent Goodrich, has since the filing of the request in this cause elected to participate in some but not all of the Chubbs Tabaroo wells and has executed and returned a unit-wide JOA. So XCL considers Mr. Goodrich to have elected to go non-consent under his new JOA with respect to the subject wells for which he did not participate. In short, Mr. Goodrich, Bradley Goodrich, as presumed heir of Brent Goodrich, is no longer subject to compulsory pooling and has been removed from the request. In addition, as addressed in paragraphs 16 and 17 of Mr. Annenson's declaration, there were several estates named to be pooled. Again, XCL believes it has leased and located all of the known heirs or successors of these estates. However, because of a lack of sufficient probate documentation, XCL cannot be certain of that fact and provided the requisite notice of opportunity to participate to each of these owners by publication as authorized by the board on September 17th, 2024. This publication is demonstrated by the Exhibit 13 on file, which is an affidavit demonstrating publication. Again, as in the last matter, there's one estate to be removed. That is the estate of Jerry Deans. XCL was provided with sufficient evidence of the distribution and leasing of the estate that the Deans estate can also be removed from this matter. Finally, as reflected on Exhibit 8 and as discussed in Mr. Annenson's declaration, paragraphs 29 through 31, the average weighted fee landowner's royalty as of the date of spud of the first Chubbs Tabaroo well is 17.795890%. And with that, I'll begin with my examination of Mr. Annenson. Mr. Annenson, can you please state your name and your business address for the record?
Kevin Annenson, Vice President of Business Development and Land.
Okay. And what is your business address for the record?
600 North Shepherd Drive, Suite 390, Houston, Texas, 77007.
Thank you. As the VP of Business Development and Land, is it safe to say that you exercise responsibility over this drilling unit, among others?
That's correct.
Okay. Are you aware of what's been filed as Exhibit 11? As Exhibit 11 in this cause, Declaration of Kevin Annenson?
That's correct.
Okay. Are you aware of all the allegations in that declaration?
That's correct.
Okay. Did you execute the declaration or cause your counsel to execute it on your behalf?
That's correct.
Okay. And I mentioned in my brief introduction, there were two parties to be removed from this. One is the estate of Jerry Deans, and the other is Bradley Goodrich, presumed heir of Brent Goodrich. Can you confirm that those are the two parties being removed from this matter?
Yes, I can. That's correct.
Okay. So does your declaration filed as Exhibit 11, does it constitute your full and accurate testimony in this cause?
Yes, it does.
Okay. Last question for you, Mr. Annenson. You've been recognized as an expert in petroleum land management. As an expert, was it your opinion that the terms and conditions of the JOA submitted as Exhibit 7 in this cause are fair and reasonable and justified to be imposed in this matter?
Yes, I do. That's correct.
Okay. With that, I have no further questions for Mr. Annenson.
Thank you.
Division?
Mr. Anderson, just a quick follow-up on Bradley Goodrich. Can you help us understand why, and perhaps you don't know, but to the extent you do know, why he only elected to participate in 3 of the wells and not the others?
I don't know why he chose to participate in only those three. Could have been a money issue, could have been those are the only three that he thought were good wells. I would only be speculating as to why he only did those three at this point.
Sure. But he did execute a JOA covering the entire unit?
That's correct.
All right. That's it. Thank you.
Thank you.
Yeah, I have a few questions along those lines about Mr. Goodrich. He is going to be a working interest owner on 3 of these wells, correct?
That's correct.
He is given his lease for all the wells?
He does not have a lease. He participated with his unleased working interest. Or his unleased mineral interest, excuse me.
That's right. So there's two options, right? When you get an election, you can elect to lease
Yeah.
or to participate. And that's the alternative to leasing. And participating means you pay your share of costs of the well, and you get to basically reap the benefits of the entirety of your own.
The other, so there's 3 wells he were involved with. The other 10 wells, he's being forced pulled in.
He's being pulled under the terms of the JOA. So he's not being forced pulled on those. He did not take any lease. He kept it as unleased ownership.
So
that's something, is that fairly new? I mean, I've not seen this.
I mean, you typically don't see people that only do it in like 2 or 3 wells. You know, usually folks will participate in all of them, or they'll just lease. You know, but it's just, you know, I guess he's just marked it to the beat of his own drum on what he wants to do there. And I think we would just be speculating as to why he only did those 3. So,
Yeah, I'm not concerned with why or what he did. I'm just concerned with the mechanics of it. So it makes it more complex on XCL's end.
yeah, it does. I mean, but we'll set the other wells up, or the ones he didn't participate with his JOA, you know, pooled interest, and then the others, or excuse me, pooled interest, and then under the JOA and the others, he'll be a working interest partner. So, you know, ownership's, you know, usually pretty complicated. So we've got a great team that's able to do that for each individual well, and that's how we'll treat it. It's definitely unique, right?
That's it for you guys. I don't think we have any further questions on this matter.
Move on to Mr. Gravy then.
Mr. Gravy, are you available? Can you please state your name and confirm that you have the same business address as Mr. Anderson?
Yeah, Mark Gravy and Kevin Anderson have the same business address.
Thank you. Can you please state your job title and your general responsibilities as they relate to the unit?
I was the Executive Vice President of Reservoir and Development. Responsibilities are to plan new wells for the development of the asset.
Development of what? Development of what?
Can you repeat that last part of your sentence?
Yeah, to plan new wells across the asset, just how to develop the resource in place.
Across the asset.
Across the asset.
Yep. Perfect. Mr. Gravy, I'm assuming you're aware of what's been filed as Exhibit 12 in this cause? Your declaration. And have you read, reviewed, and are you familiar with all the allegations in that declaration?
I am.
Okay. Did you execute the declaration or cause your counsel to execute it on your behalf?
I did.
And does the declaration constitute your full and accurate and complete testimony here today?
Yes, it does.
Okay. Couple quick questions on, you've been also recognized as an expert on this cause. In your opinion, do the actual cost of each of the Chubbs Taparoo wells that, as reflected in Exhibit 10 on file, were those costs fair, reasonable, and necessarily incurred?
Yes, they were.
Okay. And finally, do you believe the risks discussed in paragraph 14 of Exhibit 12 of your declaration justify the imposition of a 300% non-consent penalty in this cause?
Yes, I do.
Okay. With that, I have no further questions for Mr. Gravy.
Okay, thank you. The division has filed a response and notice of non-opposition to the request for agency action dated October 9th, 2024. Therefore, it's my understanding the division has no objection to the request for agency action, but reserves the right to update its response after receipt of evidence and cross-examination during this proceeding. Is that accurate, Mr. White?
Correct.
Okay, we'll now turn the time over to the division for their presentation.
Thank you. The division has reviewed the request for agency action as well as the exhibits and declarations and having heard the evidence today, has no objection to granting this request.
Okay, thank you. We'll now take closing statements from the division and the petitioner. Mitch?
Thank you. Before we do that, I'd like to move for admission of exhibits 1 through 14, which includes the declarations of both Mr. Anderson and Mr. Gravy.
Do you have any objection to that?
No objection.
All right, it's accepted.
Thank you. My closing will be simple. The statutory and regulatory requirements have been met, and the requested relief is both fair and reasonable, and also justified based on the specific facts of this case. And on that, we'd like to thank everyone for their time and attention, including the DNR staff, and putting this together, and would submit and ask you to approve the request as needed.
Division, anything to add?
Nothing further.
Okay, thank you. We moved for exhibit and we accepted those, correct? We got that on?
Yep.
Okay. Having reviewed the request for agency action, all exhibits, and having considered the evidence presented here today, I find that XCL provides sufficient notice of opportunity to the non-consenting compulsory pooled owners, and that those owners identified in their request for agency action did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find that a 300% non-consent penalty is fair and justified given the economic and geologic conditions present within these wells, and find that it would be appropriate to impose the requested non-consent penalty. I find that XCL has met its burden of proof to show they are entitled to forced pooling of the named interest and other relief requested in the request for agency action. Mr. Mayo, will you prepare a proposed order?
I'm happy to do that.
Okay, I then will present the findings and conclusions at the board hearing next week. Any other comments before we close? Okay, thank you for your participation.
Thank you.
Everybody all right? Did we break or just
No?
doing good? All right,
Burger King.
Is there a Burger King anywhere?
Have it your way. Right after this.
We're good to go. We're good. Okay. I guess I need to change my script here. It's not morning anymore.
It's, hey, look at
No, 2 more minutes, you got 2 minutes.
I have all.
Welcome to the workhouse.
Good afternoon. My name is John Rogers, and I'm Environmental Manager with the Utah Division of Oil, Gas, and Mining. I've been appointed by the Board of Oil, Gas, and Mining to act as a hearing examiner in this proceeding. Today is Wednesday, October 16, 2024, and this is a time and place for the hearing examiner proceeding for docket number 2024-067, cause number 132-62. In the matter of the request for agency action of XCL Resources LLC on behalf of XCL Asset Company LLC for an order pulling all interest, including the compulsory pulling of the interest of certain non-consenting and unknown owners within a 1280 acre or substantial equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch Colton Formation. Comprised of section 30 and 31, townships 2 south, range 2 west, and a special meridian, Duchesne County, Utah. We are holding this meeting with an anchor position in the Department of Natural Resources building in Salt Lake City, Utah. We also will be hearing testimony and presentations in person and virtually, and proceedings will be broadcast on the internet. I wish to thank the division staff, legal counsel, petitioners, and department technical staff for allowing these proceedings to go forth in person. Before we begin, I will note that I don't see any members of the public here, and if you received anything online or requests to be you heard today?
We have a couple clarifications in the declaration. No members of the public reached out to discuss anything here, but some owners reached out with concerns about their interests. There were clarifications in the declarations, and we're going to clarify those clarifications. So we'll talk about public, but
We'll know that at that time. Okay. We'll now take appearance in council this time. XCL?
Mitch Mayo of Lair and Lair PLLC on behalf of petitioner in this cause, XCL Asset Co. and XCL Resources.
Division?
Assistant Attorney General Gary White for the Division of Oil, Gas, and Mining.
My counsel is Emily McKay of the Attorney General's office. I've received declarations for this matter from Mr. Kevin Amison, Vice President of Development and Land, and Mr. Mark Grave, Executive Vice President of Reservoir, both of XCL Asset Company. I reviewed both of these declarations before this hearing. Both these witnesses have been accepted as expert witnesses in the past hearings. So I'd like to ask the division if they have any objections to the declarations of these individuals or being qualified as expert witnesses.
No objection.
Okay, thank you. They are recognized as expert witnesses in their particular field of study and work for this matter. Mr. Mayo, are these witnesses present today?
They are.
And we swear them in at this time.
Yes, please.
Please raise your right hand, gentlemen. Thank you. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Kevin first.
I do.
Thank you. Mark.
I do.
Thank you.
Okay, we'll now proceed with Mr. Mayo for his presentation.
Thank you. One clarification that I haven't made in the other matters, but I guess is applicable to all of them. The board designated this for a hearing examiner hearing, subject to confirmation that these matters remained uncontested. All the matters here today, to my knowledge, have been uncontested. So just to clarify on the record, but specifically with respect to this cause, it is uncontested here at this hearing. The board, and by designation, the hearing examiner, have jurisdiction over this matter pursuant to Utah Code 40-6-6.5. A copy of the request that's on file and the relevant documents filed therewith were sent by certified mail to the known parties to be compulsory pooled and sent by regular mail to all other production interest owners within the drilling unit at their last known addresses of record, either disclosed by the relevant county realty records or by XCL's updated searching of those records. The request was also mailed to all relevant state, federal agencies as required. Notice was provided to certain owners, specifically those parties claiming buy through under one of the named estates, was provided via publication as authorized by this board on September 17th. In addition, notice of the filing of this request and of this hearing was published in the Uinta Basin Standard on September 25th, the Deseret News on September 27th, and the Salt Lake Tribune on September 29th. On October 9th, the Division of Oil, Gas, and Mining filed a response expressing no opposition to the granting of this request pending the presentation of evidence today. I'd like to remind everyone that no other objections or responses to the RA were timely filed. To summarize, this cause involves the compulsory pooling of a 1,280 acre unit established for the production of Lower Green River Wasatch Formation. This unit was established under Order 139-140, and the unit comprises sections 30 and 31, Township 2 South, Range 2 West, in the Uinta Special Meridian. In accordance with the 139-140 order, XCL drilled and has now begun to produce from the 9 shoeless wells identified in the request for agency action. Several owners of undivided oil and gas interests in the drilling unit. Sorry, I need to quickly grab a charger here and make sure I don't lose my laptop. Several owners of undivided oil and gas interest in the subject unit and the subject wells were named in the request to be pooled as having refused or failed to lease or otherwise agree to pay their proportionate share of the costs. Several of these owners, 5 to be exact, since the filing of the request, reached out to XCL and confirmed that they would sign and return an oil and gas lease covering their interests. XCL has been in contact with them and has been assured those leases have been returned. However, despite noting in the declaration that those parties had leased, there's going to be some clarifications to that based on the fact that it sounds like the actual leases have yet to be returned. So, Mr. Anderson.
Let me ask something this time then. So we're kind of under a time frame here where this will be presented in a week from today. And you're under pressure to get that done. What will we do if those aren't presented to XCL?
Well, the good thing is all the parties who were to be removed, they received timely notices of election to participate, and that evidence is before the hearing examiner. They failed to make an election timely, that evidence is before the hearing examiner, and they failed to protest or object in any way to this hearing, and that's before you. So my short answer would be, unless the declaration convinces you they shouldn't be pooled, they should be pooled as part of this.
But if they get their notice to you in time, they'll participate.
What I don't want to do is I don't want to submit a declaration and an amended declaration, and then the next day an amended declaration.
So you're gonna draw a line in the sand at one time.
What we're planning to do, and Mr. Anderson can confirm all this when he testifies, but what XCL instructed me before this hearing they're planning to do is pool the parties, and we'll go through who those parties are. If and when they receive those leases, they will treat those parties according to the terms of those leases, and will internally, XCL's records will remove those parties from the pool order. But the board, after today, will be presented with these parties have not returned leases, and these parties are to be pulled.
So you can, even after a pulling order has been established, you can't change that?
Well, you can always come back to the board. The board has continuing jurisdiction to modify any order. You could do that. The truth is, a pooling order is essentially an offer by the regulatory body for the company to treat an owner in a certain way. And if they choose not to treat them in that way, they don't have to. They can't avoid treating them that way. But if the owner comes forward and says, "I'd like you to treat me differently," there's no reason that they can't do that, if that makes sense.
Just want to clarify that. Thank you.
And again, Mr. Anderson has a lot more of that information. He's happy to give you the clearer answer than I gave in his testimony. So we'll have some discussion about those 5 owners. Fredericksburg Royalty Limited, DT Royalty Partners LLC, BHCH Mineral Limited, Hardy Mineral and Royalties Limited, and Cheryl Elbert. In addition, as addressed in paragraphs 17 and 18 of Mr. Anderson's declaration, there were several estates named to be pooled. XCL believes it has located and leased all of them, but can't be certain. Pursuant to order of the board entered on September 17th, XCL provided the requisite notice of opportunity to participate to these parties claiming buy-through under the estates. The proof of that publication of that notice is on file as Exhibit 13 in this cause. I'd like to note that no responses were received, and so there's the estates named to be pooled in the request are still the estates that are to be pooled here today. As reflected on Exhibit 8 and discussed in paragraphs 30 through 32 of Anderson's declaration, the acreage weighted fee royalty as of the date of SPUD relevant is 17.490230%. And with that, I'll jump into my examination of Mr. Anderson. Mr. Anderson, can you please state your name and business address for the record?
Kevin Anderson, Vice President, Business Development Land. Business address is 600 North Shepherd, Suite 390, Houston, Texas, 77007.
Okay, and what is your position and your responsibilities as they relate to this unit?
Responsible for overseeing all surface, subsurface operations as it pertains to oil and gas land.
Okay, and what is your title, your current title with XCL?
Vice President, Business Development and Land.
Okay, thank you for that. You probably heard me talk about your declaration. Are you familiar with what's been filed as Exhibit 11, the declaration of Kevin Anderson in this cause?
Yes, that's correct.
Okay. And are you familiar with the allegations that are referenced in that declaration?
I am, that's correct.
Okay. Did you execute that declaration or cause your counsel to execute that declaration on your behalf?
Yes, that's correct.
Did your counsel make a mistake, and or is there a clarification you would like to make on the record?
Thanks for taking the bullet there.
That's
Yeah, we have been working with these parties to get them leased, and you know, wires obviously getting mixed up, I think, on all ends, and
Let me interrupt, Kevin, real quick, and just direct anyone who's looking at the declaration. It's paragraph 29A. If you want to follow along while Mr. Anthony explains. Sorry, go ahead now.
Now I feel like I gotta go 29A just to make sure. Okay. Yep, there was 5 parties that should have their leases in by now. There's email correspondence that they're gonna lease. And we should have them by now. And when everything was, we were working towards it, we thought we'd have them by now. So we went ahead and put them on there. We should have had them by now. We expect them to still come in. So we thought we would still move forward with force pooling them, and under the abundance of caution and under the slim chance we don't get them, we'll have them force pooled. And in the chance we do get them, then we'll set them up as their least interest under our system.
Okay, so that's a good clarification. In the interim, the board and the hearing examiner, they're going to pool these interests as requested in the request. But it sounds like you can confirm that XCL will treat them as leased according to the terms of their lease once you receive those.
Of course.
Okay.
Can I ask a quick question on the same topic?
Yeah, go for it.
Are none of the parties in paragraph 29, none of them have returned an executed lease, or just some?
I thought Cheryl Burton might have returned hers, but let me confirm that real quick. Hold on. Give me 1 second. So Cheryl Burton has returned her lease. It's the other 4 that have not.
Great, thank you.
Yeah, good question.
Okay, a couple other clarifications because of this this confusion, I guess, that's been injected through the declarations. Can you clarify, XCL sent valid, timely notices of opportunity to participate to each of these 4 parties: Fredericksburg Royalty, DT Royalty Partners, BHCH, and Hardy Mineral. Is that correct? Sorry, you're muted again.
Yes, that's correct. We've sent everybody the correct information and correct stuff in order to force pool.
Okay. And other than their emails reaching out saying they intend to lease and they've leased, has XCL received any objection or protest from any of those 4 parties related to this request?
We have not.
Okay. What is it? We have not. Thank you, Mr. Ananson. With that, I don't believe there's anything else with respect to your declaration. The division and hearing examiner may have follow-up. But last question for you. In your expert opinion, are the terms and conditions in the JOA submitted as Exhibit 7 fair, reasonable, and is it justifiable for the hearing examiner to impose those in this unit?
Yes, that's correct.
Okay. With that, I have no further questions for Mr. Ananson pending information.
Okay. Division, do you have any questions for this witness?
Nothing else.
Okay, thank you. Just want to get something clarified that I'd like to do. We have the 9 shoeless wells. Are there any existing wells in this, lady?
Mr. Amundson, do you know if there were any wells drilled in this 1280 prior to the shoeless wells that we're talking about? I'm assuming there was a Butcher Butte well, but. do you know
That's
of any
correct.
others?
That's correct. Mark might have a better answer, but there was at least a Butcher Butte well drilled there.
There was one well.
Butcher Butte well.
Butcher Butte.
And who operated that?
XCL.
So my question again is, how is that handled into the force pulling? It's just left as is?
That's right.
So this pulling order will be going forward with 9 shoeless wells and anything drilled after those.
Any drilled after those will have to be modified by the board.
Yeah,
subject
but
to the
they'll
process.
still go to the
Yes.
same pulling order.
That's exactly right.
Okay. I have nothing else for Mr. Anderson, so if you'd like to continue with your next witness.
Mr. Gravy, can you please state your name and confirm that you have the same business address as Mr. Anderson?
Mark Grady, and yes, I have the same business address.
Can you please state your job title and your responsibilities as they relate to this unit?
I'm the Executive Vice President, Reservoir and Development, and my responsibilities are to oversee the development of new wells drilled in this drilling spacing unit.
Okay. I'm assuming you're also familiar with what's been submitted as Exhibit 12, the declaration of Mark Gravy. Do you recognize this exhibit?
I do.
And have you reviewed all the allegations therein?
I have.
Did you execute the declaration or cause your counsel to execute it on your behalf?
Yes, I did.
Okay. Let me ask you kind of a random question. Does anything in your declaration need to be adjusted or modified based on the changes announced by Mr. Amundson related to his declaration?
No, I do not believe they do.
Okay. So would it be fair to say that the declaration as conformed to the testimony here today is your full, accurate, and complete testimony?
Yes, it is.
Okay. Couple last questions. As an expert in petroleum reservoir engineering, do you believe that the actual cost to drill and operate the shoeless wells, as reflected in Exhibit 10, are fair, reasonable, and were necessarily incurred?
Yes, I do.
Okay. And finally, do you believe that the risks discussed in paragraph 14 of your declaration justify the imposition of a 300% risk compensation award for the shoeless wells?
Yes, I do.
Okay. With that, I have no further questions for Mr. Gravy, subject to cross.
Dwight?
No questions, thank you.
Just another point of clarification. You mentioned there was one existing well. What distinguishes between what you're going to force pull and what you're leaving out? Is that based on the age of the well and its production cycle?
Well, I could probably answer that. That well most likely was pooled by Axia when it was drilled. The law changed 5 or 6 years ago now, where you used to have to come in and get a pooling order, do this process for every single well you drilled. And you couldn't apply it to future wells. And so most operators drilled their first well in a unit and then would come in and pool that well in that unit, knowing full well that any other wells, they'd have to come back and do it again. Since then, the law changed in a couple of ways. It allows you to pool multiple wells and for subsequent wells. And so it's a long way of saying the Butcher Butte well doesn't need to be pooled because it probably already has been pooled by Axia back when they drilled it. And the notice of opportunity to participate sent 7 or 8 years ago, whenever that well was drilled, may not be or meet the statutory requirements that were put in place for the new rules that were put in place. So there's a lot of reasons. The short answer is probably it was pooled by Axia.
So it will be governed on this pooling order, an older pooling order. Going forward, these 9 wells and anything else will be after the board would approve a new well, other than these 9,
Should be on,
but the pulling order would remain the same.
it should be under order 13262 as modified.
Okay.
That's right.
All right.
If it's okay, it's probably appropriate time to move for admission of exhibits.
Sure, that'd be fine.
Exhibits 1 through 14 in this cause. With one clarification, I will be submitting a revised exhibit 11. Hopefully tomorrow, Julianne, for what it's worth.
No objection.
No objection.
Okay.
Admitted.
So the division, as you referenced, Mr. Mill, earlier, that filed a notice of non-opposition, but reserved the right to change that with any questions they may have. So is that accurate?
Yes.
And we turn the time over to you if you have any presentation or comments on this.
Thank you. After review of everything submitted and the evidence today, the division agrees that this request should be granted.
Okay, thank you. I'll now take closing arguments. We'll start with Mr. Mayo.
Thank you. Short and sweet. We believe that all the necessary legal requirements have been met in this cause, and that the requested relief is fair and reasonable and is justified. In addition, subsequent to the close of this hearing, we will submit an amended declaration, Exhibit 11, that clarifies what was discussed here today, and will draft the proposed order, assuming this request is approved, that incorporates and reflects those changes discussed here today. With that, and with quickly thanking everyone for their time and attention to this matter and efforts, I'd submit and ask you to approve the request as conformed to the testimony here.
Mr. White, do you have anything to add?
No objection to the request.
Having reviewed the request for agency action and all exhibits, having considered the evidence presented today, I find that XCL has provided sufficient notice of opportunity to those non-consenting compulsory pooling order owners and those owners identified in the request for agency action did not timely elect to participate in wells and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geological conditions present in these wells, and find that it would be appropriate to impose that requested non-consent penalty. I find that XCL's met its burden of proof to show that they are entitled to forced pooling, the name interest, and other relief requested in the request for agency action. Mr. Mayo, will you prepare the order?
I'm happy to do that.
Okay. I then will present the findings and conclusions to the board next week at the board hearing. Are there any comments before we close? Okay, thank you. We'll thank you for your participation, and we'll adjourn this hearing. Okay, one more.
This one should go a little quicker because it's the same corrections. Those 4 parties other than that, everything's
Break, anyone?
No, Gary's gonna take us all to Burger King after.
Oh, tink you.
Got to ride on the handlebars of the bike.
I think it's closed. That's why I offered.
Okay, we ready to go, Paul?
We're ready.
Okay. Good afternoon. My name is John Rogers, and I'm Environmental Manager with the Division of Oil, Gas, and Mining. I have been appointed by the Board of Oil, Gas, and Mining as a hearing examiner in this proceeding. Today is Wednesday, October 16, 2024, and this is the time and place for the hearing examiner proceeding for docket number 2024-068, cause number 132-63. The matter request for agency action of XCL Resources LLC on behalf of XCL Asset Co. LLC for an order pooling all interests, including the compulsory pooling of an interest of certain non-consenting and unknown owners within a 2560 acre or substantial equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch Colton Formation, comprised of section 29, 30, 31, and 32, Township 2 South, Range 2 West, Uinta Special Meridian, Duchesne County, Utah. We are holding this hearing in the anchor position of the Department of Natural Resources in Salt Lake City, Utah. We'll also be hearing testimonies and presentations in person and virtually, and proceedings will broadcast on the internet. I wish to thank division staff, legal counsel, petitioners, and department technical staff for allowing these proceedings to go forward remotely and in person. Before we begin, are there any members of the public or respondents present that wish to comment on these proceedings? Mitch or Division, do you have anyone reach out to you?
No.
Okay. Okay, we now will take appearance of counsel this time. XL?
Mitch Mayo of Lear and Lear PLC on behalf of the petitioner in this cause, XCL Asset Co. and XCL Resources.
Division?
Assistant Attorney General Gary White for the Division of Oil, Gas, and Mining.
My counsel is Emily McKay of the Attorney General's Office. I received declarations for this matter from Mr. Kevin Anderson, Vice President of Development and Land, and Mr. Mark Grave, Executive Vice President of Reservoir, both of XCL Asset Company. I reviewed both declarations before this hearing. Both witnesses have been accepted as expert witnesses for past hearings, and therefore I'd like to ask the division if they have any objection to the declarations or these individuals being qualified as expert witnesses today.
No objection.
Okay, thank you. They are recognized as experts in a particular field of study and work for this matter. Mr. Mayo, can we swear in the witnesses?
That would be great. Thank you.
Gentlemen, please raise your right hand. Mark and Kevin. Can you unmute Mark? Thank you so much.
There we go.
Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Kevin?
I do.
And Mark?
Yes, I do.
Thank you.
Thank you. We'll now proceed to Mr. Mayo for his presentation.
Thank you, Mr. Rogers, and I appreciate everyone being here today. I know it's been a long time. I'd like to remind everyone this matter was designated to be heard by a hearing examiner, subject to confirmation that it remain uncontested. This matter is uncontested, and I'd just like to confirm that on the record. The board, and by designation, the hearing examiner, have jurisdiction over this matter pursuant to Utah Code 40-6.5 and the implementing regulations. A copy of the request in this matter was sent by certified mail to the known parties sought to be compulsory pooled, and was also sent by regular mail to all other production interest owners within the drilling unit. These mailings were sent at their last known addresses, either disclosed by the relevant realty records and or by XCL's internal records stemming therefrom. The request was also mailed to all relevant federal, tribal, and state agencies as required by Utah law, and notice was provided to certain owners, specifically including those claiming buy-through under the estates, by publication. That publication was authorized by the board on September 17th, 2024. In addition, notice of the filing of this request and this hearing was duly published in the UINTIV Standard on September 25th, the Deseret News on the 27th of September, and in the Salt Lake Tribune on September 29th, all of 2024. On October 9th, 2024, the Division of Oil, Gas, and Mining filed a response expressing no opposition pending presentation of evidence here today. And there were no other objections or responses received. As mentioned, this cause is a compulsory pooling request for a 4-sectional 2560-acre drilling unit established under the 600-04 order, and which unit comprises sections 29, 30, 31, and 32 of Township 2 South, Range 2 West. In accordance with this order, XCL has drilled and has now begun to produce from the 2 Moonlight wells identified in the request for agency action. There were several owners of undivided oil and gas interests in the subject unit, subject wells that were named in the REA to be pooled because they have either refused or failed to lease or otherwise agree to pay the proportionate share of costs of the wells, including the names that appear on pages 2 and 3 of the request for agency action. There is a clarification to be made, and we'll make that in Mr. Anderson's declaration or testimony, excuse me. But several of these owners, since the filing of the request, have reached out to clarify ownership, to lease their interests, etc. Those parties and their interactions with XCL were memorialized in the declaration of Kevin Anderson filed. However, due to what has since been discovered, there's some additional clarifications to that declaration, And we will be submitting a revised Exhibit 11 after this hearing. In particular, this involves the interests of Fredericksburg Royalty Limited, DT Royalty Partners LLC, BHCH Mineral Ltd, and Hardy Mineral and Royalties Ltd. There are, let me confirm that I am correct here. There are 3 parties who were named and are being removed. And one of those is an estate, the estate of Jerry Deans. XCL has been provided with sufficient evidence of the distribution and leasing of that estate, that he is being removed, or that estate is being removed. In addition, as mentioned in prior causes here today, Cheryl L. Burton has returned an executed oil and gas lease, so she is being removed. And Bradley Goodrich, presumed heir of Brent Goodrich, has executed a JOA and elected to participate in the 2 wells at issue. So he is also being removed. Again, as mentioned, there were several estates named to be pooled. Those parties were provided with published notice pursuant to order of the board on September 17th. The publication of that notice, an affidavit evidencing the publication of that notice is on file as Exhibit 13 of this cause. Finally, as reflected on Exhibit 8 and as discussed in paragraphs 31 through 33 of Mr. Anderson's declaration, the acreage weighted average fee royalty as of the date of the first of the shoeless wells is 17.654986%.
You mean the moonlight?
Moonlight, thank you.
Just want to make sure.
Yes, thank you. My brain's turning to mush at the end of the day. With that clarification, I'll proceed with Mr. Anderson if there are any other questions. Mr. Anderson, can you state your name and business address for the record for us and unmute yourself before you do?
Kevin Anderson, 600 North Shepherd, Suite 390, Houston, Texas 77007.
Okay. And what is your position with the XCL and your responsibilities in respect to this unit?
Vice President of Business Development and Land, and I am responsible for all landman responsibilities over the CSU.
Thank you. I'm going to have you confirm what's been filed as Exhibit 11 in this cause, the declaration of Kevin Anderson. Are you familiar with all the allegations contained in the declaration?
That's correct.
And did you execute or cause your counsel to execute this declaration on your behalf?
Correct.
Okay. And there's a couple provisions that I want to specifically talk about. And in particular, it's paragraph 30 in your declaration. Do you have that in front of you now?
Yep, I'm scrolling to it right now. Okay.
Okay. I just want to confirm some clarifications. There's three bullets, 30A, 30B, and 30C.
Sure. Do you want me to run through them?
30A reflects the interests of the estate of Jerry Deans. Can you confirm that the estate of Jerry Deans is properly removed from the request in this cause?
That's correct. We removed them as we were able to get confirmation from the actual Dean estate. We'd originally added them out of an abundance of caution. But since then, we had received the confirmation that we do have the correct heirs list.
Perfect. Thank you for that. I'm going to skip B and go on to C. Can you look at paragraph C? It relates to the interest of Bradley C. Goodrich, presumed heir of Brent Goodrich. Can you confirm that Mr. Goodrich has elected to participate in these 2 wells and has signed a JOA covering the unit?
That is correct.
Okay, so he's appropriately removed from this request as well. Moving back to paragraph B, 30B. This addresses the interests of Cheryl L. Burton, and 4 other parties. Before we go into those 4 parties, let's talk about Cheryl L. Burton. Can you confirm on the record that Cheryl L. Burton executed and returned an oil and gas lease covering her interest in this unit?
Yes, that's correct.
And so Ms. Burton is properly and will be removed from this request.
Yes, correct.
Okay. Thank you. Now, with respect to the other 4 parties named in 30B, Fredericksburg Royalty Limited, DT Royalty Partners LLC, BHCH Mineral Limited, and Hardy Mineral and Royalties Limited. Can you please clarify what's going on with those and how those parties should be treated in this cause?
Sure. We've have had conversations, email exchanges with those 4 parties. We have both agreed to lease terms. We've been told that the lease has been sent back to us. So we had assumed we'd added them on there as we thought we would have them by now. We have not received them yet. Therefore, out of an abundance of caution, we thought the best thing to do for our conversations was to go ahead and force pull them. And in the case that they do return the leases, which we suspect they will, then we will set them up in our systems under the royalty that we've agreed to under those certain leases.
Okay, so it's fair to say that we're gonna submit a revised Exhibit 11 declaration of Kevin Anderson that clarifies that Fredericksburg Royalty, DT Royalty Partners, BHCH Mineral, and Hardy Mineral and Royalties are all properly to be pooled by the board in this hearing.
Right.
Okay, and subject to receipt of those leases. Once you receive those leases, you will set them up in your pay decks as subject to those leases, not as subject to the pooling order.
That's correct.
Okay. With those clarifications, I have just one more follow-up question. Based on the testimony here today, does the declaration, excuse me, question, does the declaration as conformed to your testimony here today constitute your full, accurate, and complete testimony in this cause?
Yes, it does.
Okay. Mr. Anderson, does the JOA, in your expert opinion, on file as Exhibit 7, does the JOA, are the terms and conditions of that JOA fair and reasonable and justified to be opposed?
Yes, that's correct.
Okay. I have no further questions for Mr. Anderson, subject to cross.
Okay. Mr. White, do you have questions for this witness?
Nope, everything was clarified. Thank you.
Okay, just something to clarify here. With those people being removed, probably in the last matter, the same thing, the percentage being pooled will change, correct?
Yes and no.
Not the average weighted royalty, though.
That's right. That's
right. Yeah, not the royalty, but I'm saying, normally there's a chart that says, the percentage being, working interest.
OVINTIV typically supplies one of those. OVINTIV usually supplies one of those. XCL usually does not.
Could I ask a favor to include that in there? Because the board asks sometimes what amount is being pulled, and if you got to dig through it, it's kind of.
And the reason I said yes and no is because the percentages in the request for agency action should be essentially the same. We took them out in an interim step and now we're putting them back. But we'll clarify.
Just put whatever the final number is. Sometimes it's nice to have that when they ask.
Yeah, happy to do that.
And that's all I have. Move on to your next witness.
Thank you.
Mr. Grady, you please state your name and confirm your business address for the record?
Mark Gravy, 600 North Shepherd Drive, Suite 390, Houston, Texas, 77007.
Okay, and can you please state your job title and your responsibilities with respect to this unit?
I'm the Executive Vice President of Reservoir and Development. My responsibilities are planning new wells for the development of this drilling spacing unit.
Okay. I'm assuming you're aware of what's been filed as Exhibit 12, the declaration of Mark Gravy in this cause. Can you confirm that you have reviewed all the allegations in the declaration?
I have.
And did you sign or cause your counsel to sign it on your behalf?
I did.
Okay. Did you hear the testimony of Mr. Annenson given just a few minutes ago?
I did.
And are there any changes to your declaration that are necessitated based on the answers Mr. Annenson gave?
No, not at this time.
Okay. So it's fair to say that the declaration on file as Exhibit 12 constitutes your full, fair, and complete testimony.
Yes, it does.
Okay. Mr. Gravy, before I let you go, quickly, can you confirm that you believe, in your expert opinion, the actual costs of the Moonlight Wells, as reflected in Exhibit 10, were fair, reasonable, and necessarily incurred?
Yes, I can.
And in your expert opinion, do the risks described in paragraph 14 of your declaration, do those risks justify the imposition of a 300% risk compensation award with respect to the Moonlight Wells?
Yes, they do.
Okay. With that, I have no further questions for Mr. Gravy, subject to the division and hearing examiner.
Okay, thank you.
Mr. Gravy, just to follow up on something the hearing examiner asked of Mr. Annenson. At paragraph 11 of your declaration, it has a calculation of the proportional share of cost to drill. Do you have that before you?
Let me pull up that paragraph.
Sure.
And let me,
Paragraph 11. The very last sentence, there's a calculation.
Okay.
Are you with me?
Yep.
So I guess I just want to make sure this 0.270539, that's the percentage of the parties to be pooled.
That is correct.
Okay, and that number may or may not change if you get these executed leases that were referenced in Mr. Annenson's declaration.
Kevin, please correct me, but I believe they would change if they executed.
That's correct.
Or changed what?
If they were to become executed, then that number would reduce proportionately.
And then Mr. Annenson said that's correct. Okay, that's it. Thank you, Mr. Gravy.
Okay, thank you.
I have a quick question about the pending leases. When were those supposedly executed and sent? I'm just wondering what that time frame was.
It was within a week of filing the request. I got an email from the client saying,
okay,
essentially, we can remove these parties. They've indicated they're returning their leases.
Okay. So then let's say that after the final order was issued by the board, you received those executed leases and you would treat them as lessees. Would that apply to all future wells? It would certainly apply to these wells we're discussing now, but the whole unit.
Yeah, unless it's a wellbore specific lease, it would apply to their interest. And usually the leases have language that's for a term of years and so long thereafter as oil and gas is produced. So as long as there's producing wells on these, those leases will still be valid.
Okay, great.
Okay, we'll take closing statements now. We'll begin with Mr. Mayo.
I apologize for the confusion created by the declarations. We will clarify that with counsel of record here after the hearing. But it's probably appropriate to move for admission of the exhibits. That's exhibits 1 through 10, soon to be submitted revised exhibit 11, and exhibits 12 through 14.
Okay, division?
The division has no objection to the exhibits.
Okay, so those exhibits, those revised ones, will they be included with your order? Or where will we see those? We'll just...
I'm planning on filing them. I usually just file them with Julianne.
Okay,
and
and
when she
she'll
does
set-
it, she'll circulate them. Assuming.
Okay. Okay, division, do you have any final statements?
Only that we have reviewed the request, the declarations, the exhibits, and based on the evidence submitted today, have no objection to this request being granted.
Okay, thank you. Okay, having reviewed the request for agency action, all exhibits, and having considered the evidence presented here today, I find that XEL has provided sufficient notice of opportunity to the non-consenting compulsory pool owners and those owners identified in the request for agency action did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geologic condition present in this well, and find that there would be appropriate to impose the request non-consent penalty. I find that XEL has met its burden of proof to show that they are entitled to forced pooling of a named interest and other relief requested in the RRA. Mr. Mayo, will you please prepare the order?
I'm happy to.
Okay. I will then present the findings at the board hearing next week. Are there any other comments before we close? Okay. I wish to thank everyone that participated today. It's a long day. Thank you for your patience and got a lot done. So thank you. And we'll close at this time.
Thanks all. Thanks, guys.
Thanks. Enjoy Burger King.